Okay. Excellent. Welcome, everyone. I, Council President Walsh, call the March 29th Special Council session, study session to order. This meeting will be conducted in person and virtually in compliance with the Governor's proclamation related to the COVID-19 emergency and open public meetings. There are multiple comment opportunities at tonight's meeting. There's a general public comment opportunity at the beginning of the meeting, or you can make comments after the presentation and council question and answer period on tonight's agenda items. I'll also share a summary of any comments that have been emailed regarding tonight's agenda items. So, and I guess I'm also going to mention that Councilmember DeMichelle is attending virtually with us, and so we will be checking chat and making sure that she has an opportunity to comment. So the first item on our agenda tonight is public comment. Members of the public may address council at this time in person or virtually. Those who signed up in advance to make comments will be called on first. If you're joining us virtually and would like to make comments, please raise your virtual hand. If you're on the phone, press *3. If you've joined by computer or smartphone, look for the hand icon. Where that is varies by device. One option might be to go to the participant panel and choose the raise hand icon in the lower right-hand corner. If you're in the room and did not sign up, I'll ask for other speakers before closing this portion of the meeting. So I'm going to wait a moment and see if anyone wishes to raise their hand. So, Clerk, has anyone signed up to speak or indicated a desire to speak this evening?
Yes, Council President, we have 3 people signed up to speak beforehand, and I see many virtual hands raised.
Great. So I'm just going to read our guidelines and then we'll get to citizen comments. So citizen comments are an important part of the public process. We take them seriously and factor them into the decisions we make. Please direct comments to the whole council and not to individuals. And while this is not a question and answer session, we will contact you to follow up if needed. When recognized, you'll unmute your microphone for virtual attendees or step up to the lectern for in-person attendees. Please state your name, address, and relationship to city. Speak clearly and pause frequently. Limit your comments to 5 minutes. If you're attending virtually and do not respond after your name or phone number is called, or if your connection is lost unexpectedly, the meeting will need to proceed. You're encouraged to rejoin the meeting if able. Personal attacks, obscene language, derogatory remarks, and disruptive behavior will not be permitted. So, Clerk, can you identify the first person who has signed up to speak?
Yes, Council President. The first person is John Hempelman. Mr. Hempelman, I am now making you a panelist. You should be able to see the option to unmute, and you may also turn on your video. Mr. Hempelman?
Thank you, and good evening, Mayor Polly and members of the council. I am John Hempelman, and my address is 524 2nd Avenue in Seattle. I am Land Use Counsel for Lakeside Industries. As the mayor knows from her prior service on the Development Commission, and as Councilmember Martz knows as well, I worked for more than a year in 2012 and 2013 with city staff, the commissions, the council, and the mayor to help create the Lakeside City of Issaquah Development Agreement. That's a 30-year contract between the city and Lakeside Industries to plan the uses and development of the Lakeside sand and gravel mine and processing facilities in the city. Thus, we were very surprised when we saw just a couple weeks ago that there was a proposal to adopt an amendment to the city code, specifically to the code provisions relating to critical aquifer recharge areas. In our business, we call them CARAs. And we were surprised to see that that would prohibit the same uses that were approved and guaranteed by the development agreement. It was a very concerning development. That development agreement also committed the city and Lakeside to seek new intense commercial zoning for a portion of the lakeside properties to further assure that their uses there would be continued for the period or an indefinite period of time. I also want you to know that as a land use lawyer, I have worked on best available science issues since that term was first included in Washington law. The proposed change to the CARA regulations is apparently based on best available science. But that science has not been available to us or to the PPC or to this council or to the public. So I will tell you, it's the first time in my career that I've been dealing with an issue based on best available science that is not available to the decision makers or to the property owners that are affected. Now, I think we can solve these problems. I've had a long and successful history of collaboration with the staff in Issaquah and with your city commissions and with this council. Now, I'm already discussing potential solutions with staff. But to be candid with you, we do not want the city council to move forward on any proposed critical aquifer recharge area amendments until we've had a chance to find a solution. Thus, we're asking this council to suspend consideration of the proposed amendments to the CARA regulations until we have time to meet and work with staff and present a resolution of the issue to the PPC and to this council. Thank you very much.
Thank you. And clerk, who is our next speaker?
Council President, our next speaker is Karen Deal. Ms. Deal, I am making you a panelist. You should now see the option to unmute, and you may also turn on your video.
Can you hear me? I was having
Yes, we can.
technical difficulties. Okay. Good evening. My name is Karen Deal. I'm at 42929 Southeast 176th Street in North Bend. I am the Environmental and Land Use Director for Lakeside Industries. First, I want to thank the honorable council members and city staff for the opportunity to address the council this evening. As you know, or you may know, Lakeside operates an asphalt plant and a gravel mine in North Issaquah and has been operating in this area since the 1950s. As a local family-owned company, Lakeside is committed to preserving the environment, and we take great pride in our community-centric focus on environmental sustainability. We are a proud community partner and are truly grateful for our collaborative relationship with the city, a city that we have built together for many years. During the study session this evening, you will be reviewing the natural environment portion of the city's Title 18 code update. And as you heard from John Hempelman, Lakeside would like to bring to your attention a comment letter we submitted to the council earlier today regarding the CARA issue. The letter outlines several concerns with the proposed changes to the critical aquifer recharge area, CARA, section of the code. Most notably, we want to ensure that the city's amendments are based on best available science. The city has not been able to share the scientific report that it relied on to develop the CARA amendments. However, we do understand that this is forthcoming. Therefore, to date, it is not possible to assess compliance with state law regarding best available science. In addition, the proposed CARA amendments appear to conflict with allowed uses and creates inconsistencies with city ordinance and the zoning code. For these reasons and others outlined in our letter to the council, we respectfully request the council suspend consideration of the CARA amendments as drafted. City staff and Lakeside have agreed to work together to address the concerns raised, and we are looking forward to a collaborative resolution to these issues. We are very confident that this effort will result in code consistency, protection of the environment, and water quality preservations for years to come. Thank you very much for your time.
Thank you, Karen. Clerk, who do we have signed up to speak next?
Council President, next we have Kathy McCory. Ms. McCory, I am now making you a panelist. You should see the option to unmute, and you may also turn on your video. We cannot hear you, Ms. McCory. Are you on mute? Still cannot hear you. Try one more time, Ms. McCory. We still can't hear you. Nope, unfortunately, it appears to be something on your end, and we're not sure what the problem is. If you would like, we can come back to you in just a minute. All right.
Yeah, sounds good. Kathy, see if you can troubleshoot, and we'll come back to you at the end of the public comment period. Clerk, who's up next?
Next is Susan Neville. Ms. Neville, I am making you a panelist now. You should see the option to unmute, and you may also turn on your video.
Hello. Can
Hello.
you hear me?
Yes.
Good evening, council members, administration, and other important people. Thank you for the opportunity to be heard. I live at 2825 Northwest Pinecone Drive, Issaquah, for about 26 years. And I'd just like to briefly speak about the code discussions this evening. We all know the current code favors development at the expense of our environment, especially critical areas. My hope is that our new code changes are meant to form a partnership between development and our environment rather than a conflicting us or them relationship, as we have seen in the past. And especially even in my own crusades, I have even fallen victim to this type of thinking. I believe the common goal of the new Title 18 code is to attract developers who want to invest in our community and not squeeze out the most profit and then move on. Today's agenda staff report states the objective very clearly of our goal. It is to allow developable site area to determine the density, which will reduce negative impacts to our critical areas. So I think, how do we attract developers who have the same standards as Issaquah? Beginning with clear, consistent language and organized logical format, very crucial. And I think Connie Marsh described that clearly in her email 2 days ago. Clear language creates upfront savings for developers. Ease of applications and permits will allow cost savings that outweigh less dense footprints. Planning and staff can do their job more easily and in less time. Results in less turnover and burnout. And I've just been working with different planners over the last 6 months, and we have excellent staff. So appreciative of what we have in the city to the people that care and work so hard. And lastly, I just want to say it would create less legal conflicts for all parties. I believe property owners, businesses, and healthy natural environment can coexist side by side. And I think just finding the right balance may require a little work and even courage. But we've shown that we can do that in the past, and I know we can do it. Thank you so much for your time.
Thank you, Susan. And Clerk, did we have anybody else who had indicated a desire to speak?
Yes, Council President. Connie Marsh would like to speak. Ms. Marsh, I am now making you a panelist. You should see the option to unmute, and you may also turn on your video.
Here we go. Hello, everyone. It didn't rain again today. Wasn't that fun? So Title 18, I'm Connie Marsh. I live up on Squawk. Title 18 is sort of in front of you for the first time in all of its extraordinarily excruciating detail. So it's a huge amount of information. This information has gone through in large blobs a variety of citizen commissions. It's too much, too fast to do thoroughly. So while you may look at it as if someone has groomed this information ahead of you, there has not been that opportunity in these commissions because it's just too much information. So I think it is probably your job tonight to look at it in an overarching way. Does this seem to be going in the direction that we want? Does this meet the goals that we have stated? Are we actually making things better? Will things mesh? Will we be able to build and protect our environment and reduce our impacts on climate all at the same time, given the information that you are being provided with tonight? If you feel like it is not clear that these things are going to mesh and that we are going to be using best available science, because frankly, the CARA is not the only place where we are not showing best available science, then how are we going to get that so that it's clearly expressed to everyone so that people can understand why we are doing this, so that it's not just arbitrary rules, but the rules are saying we are doing this because we are Issaquah, and Issaquah needs to have this future. And it is a future where our fish, our people, our wildlife, and our water can all thrive meshed together. Super complicated, right? Because we're trying to do it with words. So think of that concept, sort of a systems concept, as almost an overarching thesis statement for what we are trying to do. And maybe they're giving you a table of contents for that. But I'm going to talk about the individual topics. So I just wanted to try to raise your level to more of a 60,000 foot level, if you can make your brain go high while they're presenting sort of in the gears information. Thank you.
Thank you, Connie. And clerk, who do we have signed up next?
Council President Walsh, that is everybody on the sign-up list and everyone that has a virtual hand raised.
Okay, can we see if Kathy McCory is available again?
Ms. McCory has logged off and has not logged back on.
Okay. Well, Kathy, if you are watching, we will have another comment period after each of the agenda items, so please feel free to speak at that time. So I also want to remind everyone that the City Council, you can always email citycouncil@issaquahwa.gov, and we appreciate receiving emails. We did receive emails, 3 emailed comments related to ID 1042, Title 18 Natural Environment Review, but all 3 of those commenters who emailed have also spoken tonight, so I'm not going to further summarize those comments that we received. So we'll move on to the first agenda item, which is ID 1042, Title 18 Natural Environment Review, presented by Minnie Dalawal, Director of Community Planning and Development. Minnie.
Good evening, Council and members of the community that are watching. It's surreal to be here in person on my first council meeting. So glad to be able to present the first topic of Title 18. And I'm going to try and share my screen, so bear with me for just a second. First council meeting since you've been hired. Yes.
And while you're working on sharing your screen, I just, Barb or anybody online, if you're having trouble hearing, just please make a comment in chat. We'll make sure.
So this is a land use code update. As we've briefed you in the past, we've divided it up into 6 groups. So tonight, we're seeking your input on the Title 18 Natural Environment Regulations. And specifically, we're asking you if there's any other considerations that you don't see in your packets that you would like Planning and Policy Commission to study before they can finalize their recommendations, and then we will come back to you with the final recommended draft towards the last quarter of this year. Do the proposed changes meet the goals and outcomes that you had intended for this update, for this particular topic? Are there any additional topics you'd like staff to consider when making the final edits to the draft code? There are multiple topics in this first subtopics in this bigger topic. So geohazard areas, wetlands, fish and wildlife conservation areas, CARA, you've heard about some comments, so critical area recharge areas, shoreline master program, and outdoor lighting. And just to kind of, go back to the initial goals that the council had worked on in, that have helped guide this update. Protect forested hillside, conserve and protect the environment critical areas, enhance wetland and riparian corridors to improve fish and wildlife habitat, retain neighborhood charm, ensure we are taking into consideration the sustainable goals and climate change goals, modernize the code and incorporate the best practices. So these have been our guiding principles throughout this process. And what we've done when we first started this.
Director Dhaliwal, if I'll just,
Yeah.
excuse me, Councilmember Martz, do you have a question?
Yeah, I had a high-level question.
Sure.
About Title 18 in general. Sure. We have a number of development agreements in the Valley floor. We heard Lakeside mentioned. We have Rowley Properties. We have Costco. We have the Villages. And correct me if I'm wrong, but those development agreements have locked their development environment in place, right? So my understanding is this is not really an issue for them, is it? Because I thought the whole point of a development agreement is you basically you sort of set in stone the development environment that those organizations will be able to have for a certain amount of time. Am I understanding that right?
Yes, I think the development regulations of 4, we shared with you a map of the main ones that the city's entered into, and the expiration and the term limits for those are, decades long. The details of what they are really subject to, what the contract really applies in certain cases could vary between the 4. So it's not. It will depend on the terms of the agreement or the contract between the different things. So I think what you heard tonight from Lakeside is more in terms of not necessarily how the development agreement really supersedes this or not, but whether they become non-conforming after the development agreement sunsets.
Okay. So it's an issue and I'm trying to make it not about Lakeside, but just
Sure.
to understand broadly what we're doing and how it relates to the various areas that we have
Correct.
development agreements with. So the concern of anybody might be when their development agreement expires and what
That's
their environment will look like when it expires.
Correct, but also the terms of the agreement for all of these 4 ones that we have, whether they, what those agreements were in terms of natural environment topics, we'll have to take a deeper dive into all 4 of them to really understand which ones they apply. But those are contractual obligations that the city has entered into with those 4 property owners, so.
And in cases where it does spell it out, it will supersede our changes.
Correct.
Okay, thank you.
Yeah.
I do want to weigh in just really briefly. I'm Anne Marie Soto, Deputy City Attorney. I haven't met any of you in person yet. So one thing to keep in mind is that development agreements will have a provision that provides that in the event that there is a life safety regulation that needs to be adopted that would supersede the language in a development agreement. I'm not saying that that necessarily applies to things we're talking about tonight, but that's something else to consider.
Thank you.
Great. So in terms of the process, so when we first started in July, August, we called it a gaps analysis, but it was really our way of figuring out and getting some policy guidance before we created the first draft. So based on that public outreach and engagement and conversations with Planning and Policy Commission, Environmental Board, that factored into creating the draft code. So we released the draft code about a month ago. Prior to the public hearings, we had an open house. We notified all the property owners and residents. 20,000 postcards were mailed. We got some good turnout at the open house. And then the Planning and Policy Commission deliberated on March 24th, last week. And that we've brought that forward to you. So you have your discussion drafts and you have the summary of the Planning and Policy Commission and Environmental Board of their recommendation to you. Obviously, we're not done with this. This is one step in the middle of the bigger process. So based on the input that we're going to get from council tonight, we do plan to go back to Planning and Policy Commission. We're thinking we'll probably need one more meeting before this combined draft. At the time we wrote this information, we were thinking we would wrap up our conversation with Planning and Policy Commission on March 24th. At the last meeting, last Thursday, Planning and Policy Commission would like one more meeting with them to close the loop on some of the topics that we ran out of time at that meeting. So we will take your information and close the loop with PPC before this public hearing on the combined draft in August and September, and then at the end in September, we plan to bring the entire consolidated draft back to you. So what's included in your packets and information today is really at a high level some summary of the proposed changes and how they meet the intended goals, what we expect the outcome from those proposed changes is going to be. You also have a summary from Environmental Board and Planning Policy Commission's feedback. We also gave you a chart that includes the public feedback loop matrix. I think we heard a desire to know how the public input has factored into the code update. So in that chart, you see your goals and outcomes that were established at the beginning, what initial high-level feedback we got from the public and the Planning and Policy Commission, some highlights in the draft code, and then what some high-level feedback we received from the community. And so it's going through all of those, and of course the draft code. So the rest of the slides we have are on each topic. We wanted to just provide some high-level summary for you. One question I have for you all is, should I just go through all the topics, or should I pause after each topic for a discussion on that topic?
So I was thinking that this is pretty big and meaty and that it might be good to pause at the end. Okay, fantastic. We'll pause in each section for questions.
Great. So the first one is the geologic hazard areas. So there are 5 of them: coal mines, erosion, landslide, seismic hazards, and steep slopes.
Give me one moment. We've got a question from Councilmember DiMichele on process.
Thank you. And it takes a little time to get your comment into the chat, so my apologies. Director Dhaliwal, you used the word recommendation, and as I'm reading the letter from the Environmental Board, the document we received was comments, a summary of the comments, but it's my understanding that neither PPC or the Environmental Board have yet reached the place where they are sending us a recommendation. Is that correct? Am I reading that correctly?
You're right, Councilmember DiMichele. The Environmental Board is not going to make a formal recommendation. That recommendation will come from Planning and Policy Commission. But the way we've structured this whole thing is we're getting their input to PPC. So, we've had these joint meetings, but under the code, under the state law, the formal recommendation will come from Planning and Policy Commission. So I think they weighed in on a lot of things, Planning and Policy Commission, but there are just a few things where in your attachment, where we captured their summary, they wanted a few more, additional discussion. So that's correct. They haven't formally given you a recommendation, but for the most topics they have. I mean, they ran out of time to talk about outdoor lighting, for instance. So that's not formally, their recommendation. They may ask for a few more changes in the lighting section.
Okay, thank you for the clarification.
Thanks.
So the geologic hazard areas, what we've done with this code is going to really help us as we look at these applications, because a lot of discussion and debate happens on who's actually prepared these reports. Are they of good caliber reports? Because these are very technical things. So we've defined the roles of these different professionals. We've identified how some of these things can be mitigated. General guidance for peer review requirements. We have a nice chart that was included in the summary documents about the buffers. So coal mine hazard, for instance, did not have buffers, so we've added those. We've really put a focus on creating really clear criteria when you were asking for reductions from steep slopes. And then also added some language where we can ask for additional buffers when we have concerns with landslides or steep slopes that require a larger buffer. I think there were some public comments, so we have a little graphic to kind of go over what is what's in the code. So 40% slope, this middle section, you cannot do any development on it. So you have that protection already in the code, and that's proposed to remain. The buffers along the top of the slope and the bottom of the slope are 50 feet. And in addition to the buffer, you have a building setback of 15 feet. Again, like I said, this 50-foot buffer can be reduced if it can be determined that it's safe to have a reduction. So that was point of discussion and debate based on public comments at the Planning and Policy Commission. And so we posed a question with PPC whether they wanted to further tighten this requirement, and I think the majority said yes. And one of the options we presented to them was, if the vertical height of this is only a 20-foot height versus a 200, that perhaps that can be a sliding scale. So we'll come back with some options for Planning and Policy Commission to weigh in on further tightening. Of course, we already don't allow development on 40% slope. We already have a 50-foot buffer. If we can justify a larger buffer for certain circumstances, we will give it some more consideration, but it'll have to be based on technical reasons, not just protection of the slope, because it's already protected. So that's one topic in this area. I think that's the main one that everyone had a concern about. The other topics were really technical. Like I said, we've captured all the things that will help us get really good reports, have some consideration on that. So that sort of is highlights of the first topic.
Okay, do we have questions? Councilmember Martz and followed by Councilmember Hunt.
So we have a CARA map. Do we have city maps for the other geological hazards?
We do, but the assessment still has to be done on site. So we have coal mine hazard maps that we know of some of them, but when we get a development application on a project, we ask them to do a topographical survey, make sure the geotechnical, soil data is correct and all that. So we do have some maps, but they are not fully accurate and complete. They're based on Department of Natural Resources that shows landslide potential, liquefaction maps and things. So they're done at the state level that take into consideration some of those things, but it's not a complete and absolutely, that if it doesn't show on the map doesn't mean that there's not protected. You still need an on-site assessment.
All right, so I ask, not unrelated, I have both steep slope and scarp on my property. Curious just how, I guess as a policymaker, I'm just sort of trying to understand how that particular example works going forward with code revision. But it does seem like it would be probably as policymakers, separate from where we each happen to live, it would be worth understanding how extensive these hazard zones are, generally speaking, right? How broad is the 40% slope, generally speaking, in the city, and so on and so forth.
Yeah, we did create a map that showed the 40% slope and then anywhere from 50 to 40%. I can try and find it. I mean, during our gaps analysis, when we were talking to Planning and Policy Commission, we had, and you can see a lot of the city is steep slope. I mean, there are very few areas that don't have some critical area on their site. If it's useful, I can pull it up.
Not this very second, but if you could send it to the council
Yeah.
Afterwards, that would be helpful. Thank you.
Will do.
Councilmember Hunt?
Thank you. At our previous meeting, which was in September of 2021, I believe, we had a conversation about how there were some exceptions, or there were some times where you could develop in critical areas, and we as a council were talking about how we could best minimize that, or wanting to best minimize that. And so I wondered if you could review under what circumstances you would be able to build on a critical slope in this with the revisions that are proposed.
Yeah, no, great question. I think I remember the conversation in September where we said if your property was completely covered with 40% slopes, and government regulations cannot prevent the economic value of your property to zero. So in those cases, we would have to have some reasonable use of their property, which could mean taking a look at how big the property is, and it could just mean one house on a property if it's zoned single family use, or it could mean that an access road is needed to get access to the property, and that's the only way they can get the access. But in order to pass the requirement for reasonable use, we would first see if a variance is needed, which is a public hearing process. And the test there is, it's a hardship. It's, for a variance, it's slightly different than a reasonable use exception. So reasonable use exception is no other use of your property can occur, and therefore the city has to allow some use. And we've beefed up the criteria for that, and have in our code tried to separate those two. Those were the two examples, I think. Between the old code and this code, I think the process is improved, the criteria for the code is improved, but it's just a legal requirement that we have to give people due process to be able to do something with the property if the entire property is 40%. But they would still go through, can you avoid the impact, can you minimize the impact, and if not, then what is the least amount of design? Separate from this, we're also talking about a terrain management chapter, which is not in your draft code, but that'll look at minimizing cut and fill, but that, on slopes that are less than 40%. So right now, we don't have any sort of design considerations for slopes that are smaller than 40%. So that's under development.
Okay, thank you. I think an ask then would be, in addition to the maps that Councilmember Martz asked for, if we could get a sense of how many parcels and the area of parcels that are completely encumbered with the 40% or critical area, that would also be helpful, because that remains a concern to me. And then my next question, which you mentioned, the reasonable use. Throughout the code, there's reasonable use, and there's also, in the critical areas, it also introduces reasonable economic use under the guidelines, and says that this chapter is not to, it is not the intent of this chapter to make a parcel of property unusable by denying its owner reasonable economic use. And so I wondered if there's a difference in those definitions, and if the reasonable economic use is defined somewhere in the code.
No, good question. I think we used to have a definition for reasonable use exception, so that came in as public comments, and we do intend to add a definition for reasonable use. And once this whole thing is, if there's inconsistency between some other definition, we will take a look at that.
Okay, so reasonable economic use is reasonable use, they would be
That
the
is
same?
how the reasonable use works. I think there was some confusion in the code language before because it was conflating the variance with a reasonable use. And so, so we've separated that out to a variance is just from a standard, what you need, it's a hardship standard, but it's a much higher bar to apply for a reasonable use exception.
Okay, thank you.
Any other questions? Okay, I had questions on the terrain management chapter that you said is under development. Can you, excuse me, I swallowed water wrong. Can you give a sense of when that is going to happen, when we'll get a chance to review it, when PPC will have a chance to review, and whether we're going to then receive the feedback from PPC about that chapter?
Yeah, so that's, I believe, the last number 6 topic. So that's a brand new chapter. So we've had discussions with Planning and Policy Commission at the policy guidance gaps analysis phase, but we haven't drafted the language for the code or graphics and things like that. But it will come back to council in summer.
So should we consider, obviously the community has a lot of concerns about development on steep slopes. So would concerns about that be addressed in the terrain management area, or is that better addressed in the natural environment area?
Yeah, so the focus of the geologically hazardous areas is really public safety. Can you build on these things and what you need to protect, a landslide, seismic hazard? The terrain management is more about design. If you have and that'll be on slopes that are less than 40% because we don't allow development on 40% or more. So it'll be the smaller slopes, but what does that design look like? How do you incorporate that into, so it's not, it builds with the hillside, so to speak. So as opposed to, so it's more aesthetics and cut and fill reduction and those kind of things, not so much as public safety aspects. That's the focus with this section here.
Okay, so in your memo, it talked about, or in the summary of PPC's feedback, it talked about the steep slope buffer and how there was a disagreement between different PPC members. So I'm wondering if you can talk through what that disagreement was, what the two perspectives were, and how staff's proposal responds to that.
Sure. So it came as part of the public comments, whether that we, have not eliminated the buffer reduction. And that came in through the initial public comments at the gaps analysis that the city grants these buffer reductions from steep slopes all the time. That there should be some bookends on when these are granted or not granted. So our attempt, based on science, was to say, this is the criteria for when you can get a buffer reduction. So we beefed up the criteria in the code. But I think we still got some comments related to, you can reduce it to 10 feet under the current code and the existing and the proposed code, that was too little. And so the discussion was, what are the options? And based on our consultant, Jim Johnson, and my discussion about how, are there other options than just a 50 feet and a buffer reduction if it meets this criteria? His suggestion was perhaps we can look at a sliding scale, but we'll have to have more conservative approach for the larger steep slopes. If it's really like a cliff, then it's going to be, we'll have to put in a larger buffer for that. So he's going to think more about what that option looks like. We don't have that to share with PPC or with council at this point. But really the feedback we were looking for from PPC was, with this additional beefing of the criteria for approval and adding some language that we can increase the buffer, have we met your desired outcomes? Or do we need to go back and relook at it? And so that's where the split was. Some felt that, two members felt that we have done it. the other three said they would prefer to tighten it further. So we'll go back and take a look at, whether that 10 feet could be maybe 25 feet. Instead of picking just a number, we want it to be based on some sort of criteria, and the height, the vertical height of the slope seems to be what we would look at.
Okay, so I'm running into this issue where several times now I've heard, yes, we heard that maybe this was an issue and we're going to go back to experts or we're going to review this. I'm having a hard time understanding then when we're going to get a touch on it that's not the end point.
On these topics that we asked Planning and Policy Commission, so anything that's going to change in the draft will be folded into the consolidated draft. If council wants to get briefed prior to that of the changes that occur to the draft, we can certainly, look at coming back to you all with that, if that's what you're asking.
Okay. City Administrator Bob Quitz.
Thank you, Council President, members of the council. One of the challenges we have with Title 18 is the role of the Planning Policy Committee and the role of the City Council. I think as we have walked through this process with the council, I think staff's understanding is that planning policy will make these larger reviews with this next piece, and then we'll bring back the entire package to the council. If we would like to do something different, then that I think will affect our schedule and how we approach this is, again, for the first of 6 of these. So if we're going to come back then 6 additional times, which we hadn't planned, we would need to know that, I think, sooner than later. But I think our understanding was we would get the council's feedback at this juncture. We would take that feedback along with the community feedback, along with PPC feedback, come with another round of this, take it to PPC, and then once it leaves PPC, it would have their recommendations. And I think the recommendations may be, we agree, we disagree, but then it would come back to the council. So if you'd like to insert another piece to this, that's not what we had previously planned on doing.
So I guess I will say that if everything from the natural environment area was being given to us, then I would think that one standpoint makes sense, and maybe I'll save my stuff for comments later, but it sounds like this is not that. This is saying we almost got there, but we have these 5 areas where we either need to go back to PPC or get other information. So,
well, and we would go back to PPC with all of that. And so again, what we're going to bring back to PPC, perhaps in pieces, but ultimately PPC will receive all of this, and then they would package this up and make the final recommendations to the council. I think the hope through this process was to let planning policy be at that 5,000 foot and below level, and then let the council continue to stay at the higher level. If the council wishes to get further into this, in addition to what PPC is doing, then that I think is a different approach than we were planning on.
okay, I will.
But it was never, one last comment, it was never meant to be, we're done tonight. And, let's just deal with some things around the edges. We always knew that these 6 check-ins with the council would be still at a work in progress stage. It was never meant to be, we're nearly done, everything's okay.
Okay, I will save comments and response on that since this is question period. Any other questions on geologic hazards? No, and checking in on Councilmember DeMichelle, we're good there, so we can move on to the next section. Thank you.
Great. So the next topic is this critical area recharge area. Actually, it's critical aquifer recharge area. I think there's a typo on this one. So the aquifer of all of your, drinking water supply, 40% of the drinking water comes from these wells. So it's important for the city to protect their drinking water supply. And the city commissioned this report in 2019 where they modeled how the contaminants can get into the drinking water supply. And based on that study, which, I think you heard, where is that study? So we have a study, I think it's just not signed or something. We're just kind of making sure Geosyntech, who is the consultant who did this, signs it, and then we're going to put it on the website so everyone has it and share it with the applicants who have requested it. But basically, you've got the wellhead protection areas, which Julie's on the call here, and Gary Schmick have been the lead on this topic. So I will defer to them if you have more detailed questions on them. But Julie has a great analogy where she talks about the aquifer as a bathtub and the wellhead protection areas as a straw, drinking straw. So that's how the whole area is your drinking water supply, and then your wellheads are the areas around the wells. So both of those factor into and how the contaminants can get to and from and how long it takes them. And based on that, there are 4 aquifer recharge area that have been mapped. So as you can see, the map on the left and the right, the map has gotten larger. But since 2004 and 2019, science has improved. The way the modeling is done has improved. So there are a lot of things that have changed. But the main restrictions are for class 1 and 2 because they are more closer to the wells. And 3 and 4 are really protecting the quantity of the water over the long haul. And let's see if I can move to the next slide. So like I said, the significant changes are, recognizing the study that the city did, incorporating this map into the code, and then we looked at the prohibited and restricted uses over the long haul. What are some of the potential uses that can contaminate the drinking water supply? No new gas stations in this area. The existing ones stay. No new mining. The existing ones stay. And a whole list. So the code has a bunch of these things that are prohibited and restricted. We also have a separate chapter in the code, which is Title 13, which really has a focus on pollution prevention aspects of groundwater quality. So we do reference that. We add some best management practices there. The city runs a great program where we work with the businesses. Public Works Department runs that. And really it's an outreach, education, and all that. So we have kind of referenced that. Some of the things that we learned through this process was, the quantity of the water. Redmond, for instance, did a whole study where they figured the dewatering that happens from construction has a major impact on the quantity of the water that gets recharged. So we're looking at if there are any best management practices. They don't necessarily need to be in the code, hardwired in the code, but we probably want to have some discussion about what those might be and if we can require them. Any sort of underground construction, sheet piling, what is the impact of that to the aquifer? So those are topics that are very complex, and there is no one way to do things that we can put in the code, but we continue to study those things. Stormwater management, there's discussion with the stormwater code update as far as infiltration and recharging of the aquifer goes. So separate from Title 18, we just kind of wanted to highlight some of those things that are still at play. That concludes Cora, highlights of what the changes are.
And looking around, seeing if we have any questions on the critical aquifer recharge area. Okay, Councilmember Hunt.
There was a question raised during public comment about the study that this was based on, and I wondered if you could provide more information about that study.
Sure, I am going to defer to Julie. Are you still on here?
I am. So Julie Ortiz, City of Issaquah staff resource here on this topic. So really it was an updated modeling effort that was done via a consultant, and it looked at a lot of different things like updated USGS maps, lithology, incorporated more data into that process, and then mapped it in a 3D world. So it looked at particle transport. So if you imagine like a drop of rainwater kind of dropping on one part of the city, it mapped how that drop may travel through time and how long it may take to get to a particular drinking water well. And then they reverse mapped that as well. And so we incorporated some data that we know from some of our pumping rates from existing drinking water wells as well.
And would the findings from that be made public or shared?
Absolutely.
Yeah, go ahead, Minnie.
No, go ahead.
Oh, yeah, absolutely. We're just waiting on the signature from the author of the report. We wanted to make sure that we had a final version out to the public.
Great, thank you.
Okay, and I'm not seeing any other questions on this area, so I think we can move on to the next section.
Great. So the next one, we can pause after each one of these if you want, or we can go through all of them together. Any preference?
I think it's fine to do them together.
Okay, great. So these are, protections for these the wetland, streams, and fish and wildlife habitat conservation area really is the more protection and conserve, as opposed to the geological hazards where the focus was public safety. This is more protection of the habitat. So for the wetlands, we've taken the buffers from the newest guidance from ecology, and ecology has done a great job of standardizing how the wetlands are regulated, how they're rated, and what their buffers are. So there's very explicit, clear guidance that we've incorporated. So the buffers have gone up as a result of that, but that's the latest, best available science that's out there. We have eliminated the buffer reductions because that is what ecology recommends. And the reason is that those don't do well in the long run. People don't maintain them, monitor them, so they look at it throughout the region, and their recommendation is the buffer reductions really don't work. So we've eliminated that. Some other highlights of the changes, we used to have a density credit calculation only for residential, not for commercial, that you could get additional credit if you had critical areas. We really didn't understand how that was based in science, so we've eliminated that. There used to be a lot of confusion between, can you have an underground vault in a buffer? We've made that very clear that you can't have some of those, the full buffer protection is required. We've really stretched the enhancement criteria to the extent we could under the legal framework of, obviously, if someone owns a 10-acre site, we can't ask them to enhance the entire thing when they're not impacting. So it has to be tied to the impact, but we've taken it to a point where if it is 50%, vegetation is really not doing well, then we have some provisions where we can ask for enhancement there. This was in your packet. It really shows your current buffer widths and your proposed buffer widths. As you can see, the new guidance is based on the land use intensity, so low, moderate, and high, which was not the case before. So if you have a trail, you are a low intensity. If you have a commercial building or an apartment building or a home, you're in the high intensity. So most of the development in Issaquah will fall under the high intensity. So the last column here, those are the buffers that would apply. And we have an example here. We'd taken Planning and Policy Commission on a tour, but this is the Riva Townhomes on Newport Way, just just west of SR 900. And in this graphic, you'll see the dotted line is what the existing code buffers are. And because it allowed a buffer reduction, so a 75-foot buffer was reduced to 56-foot buffer with enhancements of the buffer. Under the new proposed code, it would be the darker brown line on the outside. So that's the 100-foot buffer, but you would need to preserve the entire 100 feet. And you can see there's some impact, but it doesn't fully prevent development of that property, but it would need to be done thoughtfully. They do have the flexibility to ask for buffer averaging, which would couple it with enhancement if they wanted to, do it in a small little area where they wanted to reduce the buffer, but they would have to increase the buffer in the other area, so the net area remains the same. So no buffer reductions, larger buffer widths, they still have the opportunity to ask for buffer averaging. I think that covers the wetland part. For the streams, kind of similar, we don't allow buffer reductions.
Excuse me. We've got two questions. Councilmember Martz and then Councilmember Hunt.
With averaging, is there an absolute minimum, and what would that number be?
Yeah, so you still are limited to, you can't reduce it more than 25%. So 100
okay.
cannot be reduced more than 75%. But if you reduce it in 10 feet in some other 10-foot area, you would increase it.
Wait, you can go down to 75 feet from the stream is the absolute smallest distance you can get from the stream.
We were talking wetlands, but yes.
Oh, sorry, from the
yeah, and
wetlands.
depending on whichever type of wetland it is, whatever the
Right.
the buffer is, you can reduce 25%.
You can take 25% off of it if you increase elsewhere, but that the minimum absolutes are 75% of nominal. Okay, thank you.
I thought that I read in here that PPC had recommended not continuing the buffer averaging, and so that would be changed in the upcoming draft.
For the streams only. Yeah, not for the wetlands, but for the streams, it was a little bit difficult, the idea was, based on public comments, that the best available science, and so is gearing towards what less, and the streams are difficult for buffer averaging because they meander through, and so, and we really don't get that many requests for buffer averaging for streams. But they're also difficult to implement because of the meandering nature of the streams and the flowing water.
Okay, can you summarize then what the rationale would be for not doing buffer averaging on streams, but continuing that practice for the wetlands?
Sure. So, in the stream section, I was going to talk about, you still know buffer reduction, so we've incorporated the fish and wildlife stream classification. So there are 4 classifications. We currently have 5. We have a 5th one that has a 25-foot buffer. So we're eliminating the 25-foot, so that's going up to 50 feet. And we fixed the definition for ditch and stream that perpetually we get debates about those. But the public comments related to streams were that perhaps we're not using the best available science for changing the buffers. And the reference was to the latest 2020 study from Fish and Wildlife that bases the buffers based on dominant tree species. And so our analysis of that has had mixed results. I mean, there are a lot of people that feel that it doesn't really, in an urban environment, there are some unintended implications from that. People will not redevelop, and therefore the water quality that can improve with redevelopment potentially could not. The buffer widths, it's not the same level of guidance that we're getting from Department of Ecology for the wetlands. So there's a little bit of a distinction between best available science for streams, which comes from Fish and Wildlife, versus the wetlands, which comes from Department of Ecology. The other complicating factor for us is we have 2 streams which are designated shoreline. So those are approved by Department of Ecology. In 2019 update that we did, Ecology approved it. The shoreline designation from Shoreline Management Act has a really different, slightly different focus. So the water-dependent uses are important under the SMA. The public access is important under the SMA. GMA, which has more a focus of protection, so we have that interplay between our streams because we have 2 streams that are waters of the state designated shoreline. So given all, this is one item that we wanted to put on the whiteboard of all the things that we've fixed in the code. Because it's so new guidance, none of our neighboring cities have done these new buffers under the new methodology. Based on our discussions with Ecology, it seemed a little premature to go down that path at this point. We felt that we have taken this code to the point where we could, by putting it in 4 classifications, by increasing some of the buffers, so the 25 feet goes to 50 feet, the 75 feet buffer goes to a 100-foot buffer, and fix this definition of ditch versus stream. What we really would like to do in the future, if you agree to put it on the whiteboard, would be to do an on-the-site assessment, perhaps with Public Works, looking at stormwater and doing more of an inventory of what's on the ground, how does it impact the flood plain, how does the stormwater impact, and what are these buffers that from this new study mean in Issaquah's context. So given that we got the public comment on that, we figured at a minimum to address that public comment, we could say no more buffer averaging, so at least it'll meet those minimum buffers, which was different than the wetlands. So that was the distinction between those two.
Thank you.
The other things for the streams we did, similar density credit was in the code. We've taken, we've eliminated that. Stormwater facilities, we've made that clear. One other thing that we've added is if you're impacting a culvert, it needs to be fish friendly. So we've added reference to the guidelines that require for that. So let's see. So this is just a graph that shows what the existing buffers are and what the proposed buffers would be. As you can see, this 25-foot is going up to 100 feet. Some of our class 2, that non-salmon containing would be classified as the other one. So some of these 75-foot streams would actually become a 100-foot buffer. So there is some increase in buffers and elimination of the last type of a stream that is not matched up with Fish and Wildlife classification. Let's see. This is a brand new section that did not exist in our code. And this is the Fish and Wildlife Habitat Conservation Area. So GMA gives us this authority to have this section. And it goes above and beyond the wetlands and the streams to incorporate natural areas and habitats for plant and animal species. So anything, federal or state listed endangered, threatened, or sensitive, all waters of the state, habitat corridors, natural areas such as Lake Sammamish State Park, Squawk, and Tiger Mountain, all will have some additional protections. This is just an example of the priority habitat species map that is a state map, and you can click on your parcel and see what the priority, what important species there are. So with this code backing us up, we could get a biologist to go out to the site, determine what those protections need to be, if there are those wildlife habitat corridors or any protections, then we would have an opportunity to ask for additional protections. The last topic here is the Shoreline Master Program. This is something that I think came to council in 2019, and you all wanted some additional work done on this. One of it was, look at common line setback, and we did a study of this with a GIS and the consultant, and we determined that we could eliminate the common line setback. So it is not a huge impact to the property owners. Everyone would have to meet the minimum setback of 50 feet that we've adopted. We have in the existing code an incentive that you would get a smaller buffer and these are things that only apply to Lake Sammamish, and that you could get a smaller buffer if you reduce the bulkhead. We've looked at that, and that's now eliminated in this code, and just a requirement that if you build a new home or you're redeveloping more than 50% of the value, you have to remove your bulkhead and do a more ecologically friendly shoreline. We've added dock lighting standards, again, to reduction in lighting levels to protect wildlife and habitat. So that's the extent of changes for the SMP. And obviously, as we work through the critical areas code, I think that came into the public comments, Because the SMP has to be adopted by Department of Ecology, there are references to critical areas code, and we would update those references. We would work with ecology on that. So that's the other part that will get fixed here. I think that takes us to this topic.
Okay, so before we move on to outdoor lighting, just checking if we have any questions regarding the past few topics. Checking in with Councilmember DiMichele, nothing there. Going over my notes, seeing if I have anything. Okay, I think we are good to go on to outdoor lighting.
Great. So this one, the changes here are really, we have 3 different codes, one in the central Issaquah, the Old Town, and the CBD. So we're consolidating all of those. We're basing it on the Dark Skies Association's model lighting ordinance. We have some residential, current code doesn't really apply to residential. We're going to regulate it, but we're not going to make it so onerous and require permits for that. So the lighting levels will apply. We'll have a public outreach and educational component to get the word out on that. There are some small and simple non-residential and multifamily, up to 7 units. They don't need a lighting designer to come up with a plan. We have some more prescriptive kind of standards that they can use. Here are 3 samples. The first one, I think, is an example where it's no common open space. I think the code says 7 units. This one is 8 units, but we wouldn't really require them for a permit for lighting levels, but we would share what the code, what the lighting level should be. The middle is more of building that's slightly less than 4,000 square feet and a site acre of half acre. In these cases, we would have a more prescriptive approach, so they don't have to hire a lighting designer, but they can meet the lumens of the fixtures that they choose. The larger projects obviously would have to hire a lighting designer, give us a lighting plan, and we would review it and get it peer reviewed. Some more details about the applicability within the 3 different locations that we shared in the previous slide. Same threshold discussion. Some of the comments we heard from the public during this was not so much about the dark sky ordinance, but how do we deal with accent lighting, and is that going to be more restrictive than our current code? And so the existing code allows some of these accent lights. The language isn't that clear. Under the proposed code, it does get more prescriptive. You're limited to 15 feet above grade, so you can't have the top of the building lit up. But if there is an accent lighting and you have an eave that doesn't let the light shoot up into the sky, we have some other provisions like that. But this is one area where we did get some comments about perhaps we need to loosen it a little bit more. Again, we haven't had full discussion with PPC on the lighting topic, so we don't know exactly, if they are going to ask us to go back and look at the accent lighting a little bit more. The previous discussions with Planning and Policy Commission were really pro. A lot of people felt the dark skies was the direction we needed to go. So that's lighting.
Okay, let me see if there are any questions on outdoor lighting. Not seeing any, so I'll just go ahead and ask mine. After I read this code, I couldn't help but look around at buildings and trying to understand what accent lighting and building lighting would be allowed. And so I'm wondering, what types of buildings do we have currently? Obviously, anybody's existing lighting is not going to be impacted or have a requirement, but are there examples of situations where this could potentially come in conflict that would be good example projects that maybe PPC could review? Just trying to understand the nuances of how that code comes into play in real life.
Yeah, Lucy, are you on the call? That you could take that question?
I am not immediately thinking of projects in Issaquah where that would come into play, because that hasn't been the kind of very strong accent lighting, for instance, that you see on the T-Mobile buildings. That kind of thing's not really been a popular factor for us. But for instance, I will point out that the example on the slide that you currently see, the top one, the lights up towards the top that sort of appear right below the cornice, those would be allowed because they are captured by what appears to be an E. So not trying to exclude that. We're just simply trying to balance between highlighting the architecture and ensuring that we are in dark skies.
Okay, and Lucy, just as a note, it sounds like your mic might be having some issues. We're getting a little bit of a garbled sound, so just so that you check it out before any next steps. And it looks like we have a question from Councilmember DiMichele.
Thank you, Council President Walsh. This may be a totally off the grid question, but I'll ask it anyway. You know, I noticed over the holidays that that Front Street, we had a huge amount of lighting go in. And what I've noticed is that some of that lighting is sort of staying permanently on the buildings there. Would these proposed differences eliminate that kind of lighting that I guess I would classify as holiday lighting? Or it looked like it was temporary, but I'm seeing that some of it's becoming permanent. Do you have any comment about how that kind of lighting might be affected by these regulations?
Sure. So under our current code, you're allowed to have temporary seasonal lighting for 78 days. And what we are proposing, and that's really focused at the end of the year. What we've proposed is temporary seasonal or festival lighting limited to 60 days, because we recognize that it does happen on various times of the year. And that kind of lighting is exempt from regulation. And that's because the bulbs are pretty minor, equivalent to 70 watts. We did get questions from the public, and I think it's a really great question, that we had carried into the code the prohibition from Old Town of outlining buildings with lights. And there was the point that that is often a kind of delightful seasonal addition. And so that was one of the things that we wanted to talk to PPC about, to try and strike the right balance between making something exempt and having it around all of the time. So that's one of our policy questions for them.
Thank you, Lucy.
Okay, and Lucy, we're still getting quite a garbled check, so just may want to reconnect or something like that. Yep, thanks. So do you have a little bit more summary before we go to general questions and public comment?
No, I think we just wanted to say what the next steps would be. Like I said before, we'll need to go back and circle back with Planning and Policy Commission after this meeting, before we do a public hearing with PPC on a consolidated draft, and then your formal review and decision will occur in September to December. But we're hoping that today you can at least give us some high level guidance on, do you think that we're headed in the right direction, the proposed changes meet the golden outcomes, Or are there any additional topics that you'd like to see in the final draft? That's it.
Okay, go ahead.
And Council President, just the note on the last slide regarding the next meeting date. We actually are thinking that we would take the next Title 18 topic and send it to the appropriate committee. That's being looked at for the following week, I think May 3rd. So that's, I think, probably what we'll end up doing, unless the council, we got a lot of stuff for that last study session, so we would prefer just to move it a week.
That's right, yeah. I did talk to Tisha, so yeah, that is incorrect on the slide. April 26th, instead of that, it would go to the committee's structure that the council
In May.
has. Okay.
Yeah. Okay. So I'm going to see if we can ask some general questions to make sure that, anything that didn't fit into any of those individual buckets. And then after we finish with questions, we'll go to public comments. So Deputy Council President Hall.
Thank you. Just real quick then on the timeline, since that was just up. So between September and December, coming back for final City Council review and adoption, is that at a regular City Council meeting we get kind of one touch when it's all put together for adoption, or are we imagining that coming to a Council of the Whole meeting first, as we're seeing it as one package for the first time, and then a regular meeting? Have we thought that through?
Yeah, I anticipate it'll be a few meetings with the council at that point, and committee of the whole before you're taking action. You might want to make some changes at that point or whatever. So I'm expecting that we will come to committee of the whole, get feedback, come back again to the committee of the whole, and then bring that as an ordinance or a series of ordinances for adoption.
Okay. Well, and it might not be that we have any, suggested changes at that point, but to have several weeks to read it is also helpful.
Yes.
So, yeah.
Absolutely.
Thanks.
Councilmember Joe.
Thank you. I'm not sure several weeks will be enough time, but we'll see. Thank you for the hard work on this Title 18 project. I wanted to comment that I really appreciated eliminating the 25% buffer reductions for wetlands. Oftentimes there would be a development that would come in, it would get the special treatment, so to speak, and have a reduction in its buffer. But then as time went on, as you pointed out, the buffer would be reduced by people putting a shed there, or perhaps a parking space migrating a little bit into the buffer zone or what have you. And I really appreciated the fact that you took a look at it and tried to find ways that would reduce the burden on the code enforcement person or the planner having to come out to that location when they get a phone call from a neighbor or a phone call from a concerned citizen, and then having the code enforcement person or the planner having to interpret the code or measure out the distance and then try to find some mitigation or some solution there. I was wondering if there are other opportunities, as you've looked at Title 18, where we can reduce the burden on interpretation for either planning or for the code enforcement officers, so that we are more certain in our code in terms of what we expect, so that the developer or the person that occupies that facility later will know that the wetland buffers are there for a reason, they should be maintained, or are there other areas in the code, Title 18, excuse me, that you're looking at where we can reduce the burden on our staff and our code enforcement to have to go out and do that kind of meticulous enforcement. And I don't necessarily need an answer today, but if there are, I'd certainly like planning and code enforcement perhaps to get together and see if there are other opportunities where we can take advantage of that in Title 18 as we go forward.
No, absolutely. Good question. I think through the code update, we have that filter on because our current code has a lot of these things called administrative adjustment of standards without really a good criteria, and it's very arbitrary sometimes, in our opinion. So that doesn't work for staff, that doesn't work for the applicants, because we can't give them a yes or no answer. It's a maybe, and then it'll get folded in at the tail end of the project. So we obviously want to clean up those pieces that are those gray areas, and be more predictable in our code, for sure.
Great, thank you very much.
Okay, trying to see if we have any other general questions. Okay, let me look over my notes. Okay, so similar toward that idea, one of the comments that we received was about tightening up language so that the code language is more enforceable. And so I wonder how we plan to approach that. Do we have a general approach? Do we have at what point are we looking and doing a review toward the shall rather than may, and any of that type of language?
Yeah, our intent was to have the style guide where we were really clear about when to use the certain terminology so it's consistent. So when we embarked on this journey, we have that style guide. We kind of follow the rules for when this term is applied and when it means. Obviously, when we are writing and it evolves through the public process and the comments are added, we will do absolutely, we're committed to doing an editing and cleanup of the language and making sure where we have a word may, it's really clear that it's not just discretion that someone could use it to argue their way out of the discussion. So, and then in addition, the reference checks and all that. So that will, once we get the policy and the big issues taken care of, we are trying to be upfront and be clear with the language, but it will need the scrub once all the different buckets are done and consistent. So we'll continue to revise and revisit those issues.
Okay, so I'm hearing when the policy is kind of decided, or when you've gotten that point and we've finished the buckets, then you plan to do a full review. So that will happen before it comes back to council for that
Correct.
longer set
Yes.
of review.
Yes.
Okay. Okay, and Deputy Council President Hall.
Thank you very much. Director Dollywall, I was wondering if you could speak a little bit more to the feedback that we've gotten from Lakeside Industries and how we're working with them. They referenced in their letter and tonight during public comment that they were working with staff, and I noticed in the spreadsheet that we have too that we were meeting with Lakeside representatives is scheduled to discuss proposed regulations. So I was wondering if you could speak to this a little bit more, and if the administration has any updated recommendations on how to move forward based on their.
Sure. We're absolutely committed to working with them, understanding their concerns and explaining what the regulations are really intending to do, which is to protect the drinking water supply, not necessarily to have a negative impact on any business, but just watching out for the long term of drinking water supply. So I think I've talked to John, who spoke tonight. We've had good communication, and I think we are understanding their concerns at this point. We want to share the report with them. We want to have further sit down with them to see. I mean, the code itself right now, the existing code and the new code has exemptions for mining that was put in place since 1999. So erosion hazards, steep slopes, those things, because mining is a unique thing, they were exempted from that under the current language in the code. So we haven't proposed any changes to that. The critical area aquifer recharge, I think some of their concerns are getting a copy of the report and why does the boundary snap to the parcel boundary and not have a more natural environment. So we're going to get to the bottom of those, give them the information, see how we can address their concerns. My understanding is that they're most concerned about becoming non-conforming and what that means. And so to the extent we can work with them within what we are trying to achieve and protect the drinking water supply for Cara, we'll continue those discussions with them.
Okay, so I'm not seeing any other council member questions. So I think at this time we will open up to public comment. And so clerk, do we have anybody signed up? Well, I guess not signed up, indicating a desire to speak.
Council President, I see one person, well, I see one person with their virtual hand raised. Connie Marsh. Ms. Marsh, I am making you a panelist. You should now see the option to unmute and turn on your video.
I didn't mean to confuse you. I was just trying to get your attention by raising and lowering my hand. Okay, so I was expecting actually a little stop after each topic, so you guys are you're gonna get shotgunned. Sorry about that. It's sort of the format that I'm stuck with. So steep slopes. Remember, it has to have a 20-foot rise at 40% grade before it's considered a steep slope. So if you get the map that was provided before, it does not give you that fine grain of detail. It just gives you basically an overlay of the topography, not how tall the rise is. So if you want something more realistic, I think they are going to have to do a little bit of work. So in watching our steep slope regulations for the past 20 years, my perspective on what they're doing for this changing code is incorporating what we had finally gotten to as best management practices that we have done for, I don't know, probably 8 years, and they're incorporating it into code. And so, while I think it's good to put it into code, I don't think it's tighter. I don't think it's necessarily an improvement. It's basically the same numbers, the same safety factors, and the same criteria that we had always used in the past. It's just now it's codified. And so I don't think we're changing anything or very little, very little. So the using the sliding scale for buffers at least would be something. And so I vote for sliding scales for buffers. Now let's go to variances. In the past, I've gone through the variance process a lot, and you would start out, can you fit everything in your place? Do you need a variance? Yes, we need a variance. And you aim for the variance. And they look at the property and they say, wow, we can do nothing because we are entirely critical area constrained. So a single variance won't work. It won't get us what we need. We can't develop, which led you straight into what we call the reasonable use variance in the very same chapter in a linear method, almost in a question and answer. Okay, can you do what you need to do with just a variance? Yes, no, you're still constrained. Well, we have to then look at a reasonable use variance. And to me, that makes more sense than the format where your reasonable use exemption is in an entirely different chapter, and it doesn't seem to give you a flow of where you are going to need to go if you're 100% critical area constrained. They have not changed the language in the economic use, and so it's hard to understand what language will change, and I keep smacking up against that. One thing that they did not talk about is they're adding peat as a topic of conversation for protection, and peat's been in the news lately. We excavated an enormous amount of peat for the Gateway project. And it was a terrible thing. There were no rules and regulations for it. I could not stop it. Nobody could stop it. And so we did a terribly harmful thing on our valley floor by excavating all of that peat. And so now it looks like they're going to be including some rules and regulations, or at least looking into it for peat excavation, which I think is a great thing. Now, wetlands. So again, and this was a flaw in our former code, the wetlands themselves have not been addressed for improvement. It's only the wetland buffer. So you could have a fairly poor wetland and then you'd have to enhance the buffer around it, but you'd still have a poor wetland, which we found made very little sense over time. And when there were still river and streams, there were a lot of conversations about, well, we're improving the buffer, but our wetland is filled with weeds. But we have to leave them because we aren't supposed to do anything to the wetland. And this code is promulgating that flaw. In addition to that, they are saying that they only have to improve those buffers if it goes below 50%. I'm just going to call them invasives in that buffer. But what this will do is this will just make everybody not really want to maintain their buffers except to that, you know, right above that 50% standard. So then they don't have to do anything, but they actually don't ever have to have a really good buffer. even if they had to enhance the buffer, then they have to maintain it in perpetuity to an only 10% invasive standard. So to me, that's a conflict that needs to be resolved. We need good buffers. We need great wetlands. We do not need people to erode their critical areas, because then it's going to be better for their developability of their parcels. Also, it was presented that we were taking the stormwater facilities out of wetland buffers in the public utility exemptions actually. We are allowing all of those stormwater utilities that are public to be in our critical area buffers, even in our best top quality critical areas by use of, well, they can't do it anywhere else, and it's for the health and safety. Well, stormwater, of course, you're going to get that really easily. So you can't say you're protecting if then you allow it as an exemption in the same sense. So at least be honest and say, but public utilities, they're going to be able to put all this stuff in the critical area buffers. Anyway, streams, basically, it's not based in any of best available science. In the past, when we did streams, we had a report, we groomed through what best available science was and who supported it and how and why. And now, the Department of Fish and Wildlife has come out with that guidance, which they state it can be used for best available science. This code indicates that they are using the Fish and Wildlife guidance, yet they are not using that manual as support. It sounds like people don't like the buffers that might be required or expected, and so I'm not sure that's a political debate. It's best available science. It's not who wants the buffers to be how big, right? And so I guess I insist that when we have a Title 18 update that is largely about our streams and our Chinook salmon that are endangered, that we actually insist that we get our best available science put into place during that code update, not on a whiteboard in the future. Now, I'm almost done, you guys, really I am. I've gone through each draft chapter for Title 18 line by line and edited out what I thought were issues. It's very hard to understand because of the loose language. I can't even quite fathom that they are getting toward the goals that they talk about at this meeting. And so I'm not sure, the details, the conflicts, the mushy language, the allowed deviations, that's one huge thing. And I suspect it's going to require a consultant to do that language to get it all in the same voice. And so last one is lighting. The question is, what problem are we really trying to solve with lighting? The problems that I have are safety. We don't have enough lighting. Too much light, like Costco in under development across the valley floor. It just glows. Issaquah Highlands, it glows. So when I heard this last, they were looking at single family housing and trying to regulate lighting for single family housing. And I don't know that that's the problem that we're trying to solve. I think we're trying to solve the larger situations where you have visible light pollution, and that is where this code should be focused. And indeed, that was fast, but that was the end. One last thing, if y'all want my detailed edits, just let me know. It's great reading. Bye.
We appreciate you, Connie. And Clerk, I know you're working on the Idle TV standby, but can you see if we have anybody else signed up to speak?
No one else has their virtual hand raised at the moment, Council President.
Okay, and it looks like we've got City Administrator Bob Quitz looking for a remote so that we can get the piece off of our little TV screen here. Given that we are through public comment for this agenda item, it is now to council member feedback. And so we've done questions in order, but I'm not sure we necessarily need to do feedback in that same breakdown of order. So we're looking for general feedback. There was also 2 sets of questions from the administration, which was, do the proposed changes fully meet the goals and outcomes intended for this topic update? And are there any additional topics for staff to consider when making final edits to the draft code? So, do we have anyone who would like to take a stab at first topic of Title 18 first tonight? Oh, that's Councilmember Ray.
Thank you, Council President. First, I think it's great that you're working with the Lakeside folks and that we will be able to incorporate their proposed changes into Title 18 if possible moving forward. So thank you for taking that on. I'm going to be kind of general in my comments. I think overall, I appreciate that we're getting very specific about the language and we're driving the vagueness and ambiguity that's been kind of our problems with our current code, and eliminating administrative adjustments of standards is I think, a win-win both for the people who need to permit and also for our staff. And I also think it just provides for a more transparent and more consistent government. And I think that we are doing the right thing here, and I'm excited about it. But I have 2 hesitations that for you to ponder that are very global. One is, what's the process as we go through this so in 10 years from now, we're not back here having this same conversation about the code has gotten out of alignment. So how do we make sure going forward that we are maintaining that internal consistency, and that's something that we do intentionally and not kind of ad hocly, in an ad hoc manner. And then also that we take a step back and we elevate ourselves and we say, in total, if all of these pieces are done and they're right, does it get us what we want? So, sometimes you break down your problem and you address each component and you nail each one and you sub-optimize the whole. So at some point we need to make sure that we are looking at this systematically and looking at the whole and making sure that as this code comes together, that not only is each of the components optimized, but that we've optimized for the whole.
Councilmember Hunt?
Thank you. Councilmember Ray, I just wondered if that was a question for, if there was an approach on, if you wanted to have an answer to your question on the approach, or if that's something for us to ponder.
I think it's something for us to ponder, but I also think it's something that I would love to see city staff come back with. And I don't need it today, so that's why it was more of a comment than a question. Thank you, though.
Okay. So I first wanted to say that I appreciated the chart that explains how different changes were made to address the different goals and how the feedback from PPC used or was going to be used. That's something that I've thought would be a helpful way to organize it. And it, in fact, I think really helps structure the conversation and helps me understand the materials really much more clearly. So wanted to start with that and the appreciation on that. Also appreciated the thoughtful comments that came to us from the Environmental Board and Planning Policy Commission, which are both included in our materials this evening. Of those, I think it would be helpful for future to have more of a more editing of those in terms of, there were some comments, for example, from the Environmental Board that I think were probably could have been addressed to the Environmental Board and then wouldn't need to be comments up to Council. So then we could really, have those feedback that are specific to things that Council can follow up on as policy items. So just to give an example of what I'm talking about, there was a comment in there about that staff should consider not allowing the common line setback in the bulkhead for the other bodies of water that are in the Shoreline Master Program, but it actually always was only specific to those. So just to help with our process, I think that would be helpful in the future. And then the second process thing that I would recommend is giving some time for those changes that you know that staff agrees with the recommendation on that section from Planning Policy Commission, to give some time between that meeting and our meeting so that you could flag them in the code. Because I read the code, I read our packet sequentially in alphabetical order with the items. And so I was reading, for example, that changes will be made per March 24th PPC discussion, additional options will be made. And then the thing about the buffer averaging will be changed. And then I was reading the code and it wasn't there. And I think and then, for example, I had this question about whether it was streams or wetland buffer averaging. So, and that was, I think, partly because it wasn't flagged like where it was in the code, but that there would be a change to that. So I think that would be helpful if you gave more time, and then even if those changes couldn't be made, they could also be flagged in the code so we could have that consistency. And so when we're reading it, we can better use our imagination rather than trying to sort of trace back and forth between the documents. But again, really appreciate the feedback from the commissions. So these are just minor requests that I think will help our process going forward if they could be integrated into the process for the next steps. And I also felt that it hopefully will be helpful because we have 5 more or a bunch more chapters. So we're going to do this a bunch more times. So hopefully that's useful for our process. So I reviewed the meeting we had on September 14th of 2021 to kind of jog my memory and think about what comments council had made previously. And I wanted to bring forward some of those comments for our consideration again, because I think there were a number of really good comments made. And while many of them were addressed, some of them could potentially be addressed when this comes back. One of them is there was a discussion about how, using the lens of how we honor our partnership with the tribes. I know there was a partnership with the Snoqualmie tribe to review this, but if we could specifically provide more information about how we are working with the tribes, that I think would be helpful. And I didn't see that specifically in this document. And that is a very important partnership to the city and very important to this environmental chapter and its review, I think. And that was raised by Councilmember Martz at that meeting. Another thing that we discussed and that I wanted to request more emphasis on is there seems to be a change between that meeting and this meeting, both in the materials and then also in the discussion this evening, from trying to go for ecological gain to no net loss. So in the September 21st meeting, there's specifically a discussion about how the proposed approach will align Issaquah's regulations with best available science to achieve ecological gain. And the words ecological gain actually don't appear anywhere in our packet this evening. So I do think that that is still a good, very high level, 60,000 foot, or however we're phrasing it now, a goal. I think that that should still be our North Star and should still be a goal. If we're always doing no net loss, the issue from an ecological standpoint with that as a sort of philosophy is that our habitat and our wetlands will degrade over time. There's climate change, there's a number of other factors. So if you're always just saying, well, we can't make it worse than where it is, that natural degradation over time will just keep happening. And that's, I think, not what the community expects from our code. So I would like to see that ecological gain lens applied again, and where we can see restoration instead of the no net loss. I think that would be a good pass to take over this and see if we can strengthen things, strengthen restoration, make sure we're stressing enhancement, not just not making it worse. So where possible, I would like to see that strengthened. I did find also a definition for ecological gain, if that's helpful, since it's a little bit jargony. And so it says, this is from a House bill where they were advocating for ecological gain instead of no net loss from, I think, a couple years ago. It says, under net ecological gain, proponents must first avoid and minimize impacts before moving to additional steps in mitigation sequencing. I think that would be a good standard for us. And also that the concept of net ecological gain is defined as a standard for development policy, project policy plan, development regulation, or activity in which the environmental impacts caused by developments are outweighed by measures to mitigate the impacts. So I think, again, if we could look at it through that lens and see how we can strengthen our protections and see if we could achieve ecological gains, that would be, I think, aligned with where the community wants us to go with this code update for our natural environment. And let's see. One other thing on the best available science is mentioned. There is a new best available science for the stream buffers. I do think this is our opportunity to use that, even if we're on the front end of users of that amongst the cities. So I think that would be something I would like for planning policy to consider as well when you return to them. The other thing for planning policy is the wetland buffer averaging. I personally think that the reasons you have a wetland buffer, like the wetland doesn't care where you are along the buffer, so it's all important to the ecological integrity of the wetlands. So I would like to have planning policy consider the wetland buffer averaging for the same sort of ecological integrity reasons that the stream buffer averaging is not being allowed. I think potentially we shouldn't allow that averaging. And then my last comment is one thing that, so in addition to this chart where we have the goals and how they're met by the code, which I think is helpful, if there are changes that are being made that don't address goals but are made because of other reasons, like there's a requirement in law, for example, this reasonable use section on the hazard areas, that's actually new. If there's a reason for those changes, I think that should also just be added and why, because otherwise we'll have the question of why. And so I think that will help us better understand why those changes are made.
Okay, do we have other comments? No. And checking with Councilmember DiMichele. Seeing if we've got any. Oh, you physically raised your hand rather than comment? Go right ahead. Go for it.
We'll get the system down. I'll be brief. First of all, I really appreciate the conversation that my fellow council members have had tonight. Learned a lot just from listening, so thank you to everybody. I also wanted to say that I did appreciate the layout of the information that was described earlier, responses to the comments from PPC, and I thought that was very helpful. And again, I think we've said many times that we find those charts very helpful for understanding the public input that we receive. I think overall, I'm just a little feeling a little bit that we're just not quite there yet, and I know that we're in the middle of the process. But there were things that I wondered about. For example, there were many references to putting things on the whiteboard. And I guess I would like to learn more as we go forward about how those decisions are made and why things are put on the whiteboard and not carried forward. So just something going forward again, if we could get explanations for why things are no longer being considered, that would be very helpful to me. And then I discussed with Deputy Council President Hall earlier, it would be helpful for those of us who don't have that land use background and don't have a lot of the references if we could perhaps have smaller group discussions, or as was said earlier, maybe these will get referred to our committees and we'll be able to go into more depth. But for those of us that don't have that land use background, it would have been helpful to have had more reading time, and it would have been helpful to perhaps had conversations to help work our way through the information. Because as Councilmember Joe said, it is a lot of information to absorb in just a few days. So anyway, but I do appreciate, goodness, what a huge body of work has already been produced. And I know there's going to be a lot more. So thank you to the staff for the work that's been done. Thank you.
Okay, checking again with my fellow council members. Yep, Deputy Council President Hall.
Thank you very much. Just super briefly then, so some of the directions on the record. I just wanted to briefly +1 to a lot of the things that Councilmember Hunt shared regarding ecological gain, the wetland and streams buffer considerations. I think are very interesting to hear more from Planning Policy Commission on that. And then also the tribal partnerships. I thought that was a really good point. Couple of quick things that I wanted to say in addition, mostly Director Dollywall, the rest of the staff, wonderful job. I think you guys are doing a fantastic job with the PPC and with the environmental board. I'm largely very happy with the direction of where we're headed on everything. I think there are some things where we can consider, should we be bold here? You know, ecological gain is certainly one of those things that we can get into and consider as at a high level, 100,000 foot or whatever we're calling it, policy question for council to consider. So, but anyways, largely very well done and thank you.
I noticed that our feet level has gone up from 10,000 to 50 to 60 to 100. I mean, steep slope. There we go. Way to keep it on topic there, Councilmember Ray. Okay, any other comments? Otherwise, Councilmember Hunt?
I had one other comment that I forgot to say earlier, which is I appreciate the direction that PPC is going with the additional options for further tightening steep slope buffers. And then I think there's another one where it's sort of similar, where it says, you know, considering options for reducing variances and for tightening the language. There's a bunch of things where it sounds like Planning Policy Commission made those recommendations, and those will be changed in the next draft. So I wanted to say I'm on board with those changes. It's a little hard to know because the options aren't presented to us this evening, which option would be best for that. But generally speaking, as strong as possible, I think the protections on these steep slopes should be as strong as possible, because we want to have safe developments for the public safety. This is a really important issue for Issaquah, where we have so many steep slopes. The other thing from our September 14th meeting, which backs that up, is we had this discussion about critical areas are critical for a reason. Shoreline buffers are shoreline buffers for a reason. So I think that still stands, and everything we can do to protect those areas, we should continue to move that direction, and appreciate the Planning Policy Commission also seemingly moving that direction.
Okay, so I think I'm going to take my time to give some comments. So as a first to staff, I know I have asked a lot for a lot of different ways of feedback here so that we can really understand and get into this, and I think you hit that. You did a great job providing the summaries of PPC's feedback so that it was understandable and had a sense of, you know, where the disagreements were. I think I personally preferred the environmental board's kind of the way that was kind of summarized into topics rather than necessarily the back and forth. But it really was important to me to see where there were areas of disagreement so that I could use that as a framework for interpreting the code and reading over the draft code. So I really appreciate that. The goals and outcomes chart, in being able to show that full flow from here's our goal, here's the outcome we want to see, here's the proposed change that we're going to make, and doing all of that and showing it on these kind of high-level goals of, hey, we want to protect our forested hillsides, that is also really important as a way to review our intent and what we have received as a proposal here. So I really like all of that. I also want to see us take another look at the steep slope buffers, look at the vertical heights and not just grade, give an opportunity to really do that protection that the community is looking for in lots of different ways, so that we understand that the difference between a 20-foot and a 200-foot hillside, as you said, is very much a different experience. I'd like to see us taking a look at wetlands and streams, even though the information is coming from two different state departments. Just really understanding what is the most that we can do from the protection, especially in regards to the buffer averaging. I think we can really find the science that helps us protect this the best, and do it in a way that is even and appropriate across both of those important areas. And then generally, as I was trying to really interpret some of these things, the showing the REVA project and how that review is done on the map and what the impacts of the code were was really eye-opening for me. And so I would really encourage for not just each of these big bucket areas, but for the smaller bucket areas, sub-buckets, if we should say, doing something like that. You know, I think as a council previously, when we've looked at code language, we've really liked asking for a sample project. And so I think that really helps us better understand the implications of the changes and what the outcomes are, not just what the change is and what we think it's going to do. I think it also powerfully demonstrates to staff, you know, maybe here's some of the issues we have in trying to interpret the code. And so as a practice, I think as we get into this next section, I would like to see that, whether it's something that comes to council or something that comes to PPC or both, I think that just as a tool is really important. And then on the timeline, I generally absolutely agree with the concept of the schedule that we proposed, which was go to PPC, finish up that review, come to council with PPC's recommendation on a topic. If we have questions and feedback, it goes back to PPC, but it doesn't then come back to us. In this case, I feel like there were a few areas that just didn't get to that final point with PPC, whether it was the outdoor lighting or some of these steep slope conversations, and then in general, some of the recommendations from PPC on, hey, does this achieve the goals and outcomes for each of the topic areas? So that's the only, if we had gotten through all of that with PPC and we were seeing more of a fully formed set of review and feedback, I'd be fine with the process that we have. At this point, though, I feel like there's a lot of those question marks where I just don't have PPC's review in order to say, yes, okay, we're moving along in the right direction. So looking at those questions from the administration, do the proposed changes fully meet the goals and outcomes intended for this topic update? I think I can mostly say that, but I still have questions because PPC wasn't able to get through some of those larger things. So that's where I would leave it. I guess I would ask the other council members, as we go back through those administration questions, you know, where do you feel like we are? What are there any additional topics for staff to consider, and how do we feel about that timeline? So that's my feedback, and it looks like Councilmember Martz.
Thank you, Council President. Yeah, your comments made me think of a couple things to bring up. I want to plus one on the example side. I flashed back to my first 3 months on council. We dug into the Shoreline Master Plan in 2010. And having examples, we had, plastic overlays where he said, okay, here's the situation on the ground, here's the current code, here's what it would look like. Really helped us understand the ramifications, the public policy ramifications of what we were doing. The second thing is I appreciated very much Councilmember Hall mentioning the concern I had earlier about our engagement with the Coast Salish tribes. And I would like the engagement is what it is on Title 18, but I'm hoping that maybe this year we can have a more structured way to describe how we want to engage the tribes, because I think that their input is not only ethically important, I think we have a legal and historical responsibility to make them sort of first among the stakeholders that we have when dealing with land issues due to the treaties from the mid-1800s. Thank you.
Okay, so I'm looking around the room, looking on comments with Councilmember DiMichele, seeing where, I don't know if we've gotten to the administration's question, do the proposed changes fully meet the goals and outcomes intended for this topic? Can we get a sense of, we've received feedback in various areas, how are we feeling moving forward? Do we feel like we're on target with the timeline? I want to give a sense to the administration how we feel. It's okay, it's just our first touch on Title 18. It's no big deal. Councilmember Joe and then Councilmember Martz.
Thank you, Council President Walsh. I do think we're on schedule both in terms of the topics that we're focusing on and the timeline. I would encourage the administration and the staff to fully take the opportunity to really explore the topics with PPC and the other boards and commissions. From my point of view, it's more important that they have a full and wholesome conversation about those topics and give their full impact, their full comments back to us, rather than trying to hurry a report to us that is incomplete. And I'm not saying that what you gave us tonight was incomplete, don't get me wrong, but I'm saying that even if it seems that it might put our schedule behind by a week or 10 days or whatever it might be, please take all the opportunity to get those comments from the volunteers that we really rely on in our cities and our boards and commissions to get information. And so on question number one, I think we're on top. I think we're on time. I would encourage taking all the time you need for the boards and commissions along the way. And just as a personal request, I would love to see the water modeling that talked about the raindrop and where it goes. And I'll make an appointment with the administration to try to see that model. Thank you.
Okay, Councilmember Martz.
Yeah, the cake isn't baked yet, right? I mean, we have all the ingredients are there. You know, we know there's flour involved. We know there's baking soda involved. We know there's sugar and whatnot, chocolate. But the cake isn't done. We've heard from the public. We've heard from the administration. I like the general direction that it's going, but I wouldn't want to misconstrue saying, sure, it's going in the right general direction. You know, we're still gonna, in the end, we're gonna get something that's got a bunch more work in it. And if we want to dig our heels in on an issue based on how we read it and how the public responds to it, then that may happen. So, yeah, sure, I like it so far, but it's, you know, it's still a ways from being done. Thanks.
I could take that cake analogy and just go really far with it. I appreciate it. I am now going to think of code as cake or rather the code process, writing process. Okay, so I've heard two standpoints of we're moving forward, still work in progress, appreciate the feedback that we've received and will continue to receive from the boards and commissions. Anything else? Councilmember Hunt?
There are a couple areas where Planning Policy Commission, I think, didn't, due to time, have the ability to get into those topics. There's a couple places in our memo where it says we'll continue discussion with PPC, but it really doesn't have a recommendation on those areas. So I think for those areas, because we didn't have the sort of full recommendation to consider, I think it would be helpful to have those specific areas brought back to council, but not in the full package, because once we have the full package, we're going to have a lot on our plate. So to give those sections their due diligence and have them follow the same process as everything else that we're considering, that would be my suggestion or request that we bring those back to council.
City Administrator Bobquitz?
Yes, Council President, members of the council. We're certainly prepared to do that for those items that were not done. Again, you will not all see it because it's going to now go to committee. You'll have a committee meeting once a month, and if for some reason something misses that one meeting, then it's going to miss that one meeting, and it's going to have to wait for another month. So yeah, it's going to be a very difficult next 6-9 months. Very, very difficult. Your boards and commissions are exhausted already. I mean, I think we're working to keep them interested and connected. You know, some of them are very excited about being part of this. Others of them come after working a full day and have families to take care of, and then they are not land use planners, they're not land use attorneys. And so it's going to be really, really hard. The next 6-9 months are going to be really hard. So we'll do our best to continue to keep the council posted and apprised. We'll continue to do our best to keep our boards and commissions cared for, because this is not what they signed up for. And we're hearing that already, and it's only March. And so what happens when we get to November? So again, we'll be happy to come back with those updates.
I suggest chocolate, lots and lots of chocolate at every meeting. It really helps the code go down, but that's. Cake maybe? Cake? No? Do we have any other commentary on this? Otherwise, I guess I'd like to give Director Dhaliwal a chance to summarize the feedback you've heard, ask any other questions, and give us a set of next steps.
Sure. Is Councilmember Ray?
Councilmember Ray.
Thanks, and just to come in late, I would really like, guess based on what this city administrator just said, if we're going too fast and if we're pushing people too hard and we're burning through people and we're not making the best decisions, come back and tell us to slow our roll, because this is one that we know is super important and one we know we have to get right. So if we're pushing because we put a date on the table, I think that may not be simply the best reason to push. So come back and tell us, if more time is needed, because I think we would rather do it right than fast.
Councilmember Mertz.
Plus 100 on that. Just to go back to my 2010 analogy, the update of the shoreline master plan itself was a multi-month project that involved lots of collaterals, and that's like the tiniest piece of one part of this effort, right? So it's a big heavy lift. I think, I happen to believe that having committees will allow us to provide more thoughtful, timely feedback back into the process. But whatever it takes to get the commissions and boards, to be able to review things in a fashion where they feel that they've had a proper vetting time-wise, I'm very supportive of. This is an immense amount of work compared to, the last time we were doing dribs and drabs of this over the last decade. Thanks.
Okay, and I see a comment from Councilmember DiMichele that you agree. Do you want to state that verbally so that everybody?
Thank you. Yeah, no, I appreciate the remarks about we want to get this right and rather than doing it fast. And we sure do not want to lose our volunteers that put in already an immense amount of effort. And we want this to be thoughtful. And sometimes being thoughtful takes time. So I just agree with the remarks that have already been made. Thank you.
And if I could just clarify, because the last time I characterized the Planning Policy Commission, I spent months recharacterizing it. So again, these are dedicated, thoughtful people. Communities don't have people like this. We need them desperately, all of us, every community. It is a lot. And the people who come and serve on, especially the Environment Board, for example, we're not environmental planners, environmental lawyers. They care about a broad breadth of environmental issues facing this community. And so we have asked them to become junior land use planners and junior land use attorneys. And they're stepping up to the challenge and they're embracing it as, of course, is planning policy, which always does that. But again, these are volunteers. There's only so many hours for this, and they all have other assignments. Each of these boards and commissions have other business before them, plus this. So I want to make sure the characterization is correct. We're trying to be as sensitive as we can. Certainly every one of these volunteers want to do good. They want to represent the community. They want to make sure the comments are made, but we are asking them probably unfairly to take on roles that they are not all equipped for. Certainly some of them come with those skills and abilities from their day jobs, but not all of them.
Okay, back to Director Dhaliwal.
Thank you. This has been great. I think I've heard a lot of good suggestions here. I'll go through them real quickly just so I'm clear on where we are. I also want to recognize our staff that has worked really hard, our consultant team that has worked really hard. I see Doug Yormek and Emily Appleton, our engineering manager. They've been watching this. They've been part of this situation, rewrites, talking through them and all that. I know you saw Lucy and also Julie, who's hopped off the call. But in addition to that, Jim Johnson, who's been a great resource for all the steep slopes and the landslide, because he's been on the peer review side. He really knows what this landslide over here meant and what the debates were about the topic, and we want to have the backing in the code. So it's been a team effort, and thank you to administration, to the city attorney's office for reviewing the drafts, making sure all of those, and all of your input, and boards and commissions. So it's the whole team together getting us to this point. We have long ways to go. Some of the things I want to make sure we capture as we move forward is, how do we make sure that we don't get into the same situation again? Absolutely. We will come up with a game plan of we have these periodic check-ins, a yearly housekeeping code changes that we keep up, because we'll learn as we apply the code. And then, of course, the state requires us to update these every 8 years, at least the natural environment topic. So we want to stay ahead of that. One thing I think, just so that I'm clear about, obviously the partnership with the tribes, we've invited them to our affinity focus group meetings. We've had conversations. They've submitted comments on one of our topics. The ecological gain aspects, it's going to take more than the code to get the community what they want as far as the ecological gain goes. It's the three-legged stool. You've got your regulations, you've got your capital funds that you're going to do, and the programs. I mean, you have Green Issaquah, great program that the Parks Department runs. It's going to take all those three things to get us to that ecological gain. The regulations, we are limited because of some of these things that we can only ask for no net loss. And that's where the legal boundaries kind of come in. We'll definitely go back and look at the code to look for opportunities for those gains. But it's going to take more than the code for the community desires to be fulfilled on that. The main thing, the stream buffers, we want to make sure we have our marching orders from you all. If we are going to incorporate this new best available science from Fish and Wildlife with this update, or can we put it on the whiteboard? I heard both sides, so I think I want to get some sort of a consensus of if we want to incorporate it this time, which will mean we'll have to hire a new consultant, really do some on-the-ground field work and assessment of what the state of the affair of our streams is, what this new best available science is telling us. So that'll be a project in itself. So we want to get some clear direction on are we tackling that with this update. I think some of the other things in terms of smaller group discussions, we're absolutely committed to providing the resources for the policy, for all of you, for the boards and commission. We've offered to board and commissions, one-off question and answer sessions so that they can hop on the call, not violating the Open Meeting Act, but giving them that opportunity to ask questions and get into the deeper discussions. Steep slope buffers, obviously, we're going to have that conversation with PPC. Examples, we are definitely going to try that, and I think that's a really helpful, useful tool for the PPC. We're also talking about scheduling a Saturday workshop after we get through the 6 topic areas, test the code workshop, where we can run through some scenarios. Anyone can drop in and bring in their proposals, and let's see what this means. So we're, that's in the works as well. So with that, I think if we can get some direction on the stream issue, that would be awesome.
And I think the administration's going to have to come back with that.
Great. Yeah, so Deputy Council President Hall.
Thank you very much, Director Wallywall. Just a quick follow-up question. So you said there are some areas with regard to ecological gain. There are some areas where we can really only go to no net loss. You said state law, is that right?
That's where some of the premise of some of these regulations come in, is overall for the nation, there was the I don't know if Anne Marie wants to weigh in, but there are rules that we can't tag one property owner or one development for something that they're not impacting and ask them to enhance the entire property if they happen to have a stream and they're staying outside the buffer. There really isn't that nexus for us to ask for some of those. And the basic test is that there is no net loss. There is, we can obviously go down the incentives approach. If we really want enhancement, then we give them something in return. Taller buildings, larger this, and in the past, the incentives approach was not where we wanted to go because people didn't take that incentive. I mean, we've tried that with affordable housing. You can build taller buildings if you put it but it doesn't pencil out for folks. And so if we go the incentives approach, it really has to make sense from an economic standpoint for someone to buy into that incentive. It'll feel good that we have that on the books, but the chances of someone using it will be, we really have to give the farm away to get that incentive. So that's our initial assessment of that issue, but we can go back and take a look where there may be some opportunities.
Okay, I guess I'm just curious. I asked the question because I'm curious if we're finding that we're running up against challenges with state law that limited our ability to, for lack of a better phrase, be bold if we're interested from a policy perspective. It would be interesting to develop a list of those things and then consider whether or not these are things that we might want to include in our legislative agenda moving forward. If that's too exhaustive or long of a list, I don't mean to add an unnecessary burden on staff, but perhaps if it's not that long, it could be interesting for council to review.
No, great idea, absolutely.
City Administrator Bob Quitz.
Just a further clarification on some of these things that we refer to the whiteboard. That's a Mayor Pauley term that she has, I think all of you know, adopted through this process, really to allow us to continue to focus on really the tasks that are in front of us. That there are so many other things. Just this whole conversation that Deputy Council President Hall is raising, just a whole other topic, which is really important. And so the idea is, let's capture these additional ideas. let's not lose them, but recognize that perhaps they're not incorporated right now in the work before us with Title 18. I think the three-legged stool analogy that Director Dollywell used is important too. So there may not be sections of land use law in the state of Washington that further what we want to do, but there may be other approaches, either through other initiatives, through financing of other projects, will allow us to do that. So I think the mayor feels really strongly that we have to continue to look at this very holistically, and by looking at it holistically, part of it is saying there's going to be additional work to be done. When we're done with Title 18, we're not done with Title 18. We're done with one piece, and there'll be additional work that we'll program and start working and thinking about immediately.
Councilmember Hunt.
Yeah, I appreciated the three-legged stool analogy as well, and I think that is definitely an approach we will need to do. And a lot of the comments also from both the Environmental Board and the Planning Policy, there were some comments that weren't really probably addressable in code, but go to that three-legged approach to address, things like education or the green Issaquah things that I think go towards some of these comments, but wouldn't probably be addressed in Title 18. That said, I went down a research rabbit hole on ecological gain earlier today, so I will just add to Councilmember Hall's question that there was a bill in the State House, HB 2550, which is the one that I quoted the ecological gain from, and that didn't pass, but that was to basically do this review of changing the standard from no net loss to ecological gain. And so if you look that up, I was reading the review of that, and so it goes into what it would be and how you could use it. So I do think, though, there are still opportunities to go above what we have right now. And so that's what I'm asking, is if we can review the code with that lens and look for those opportunities. Also within no net loss, there are sometimes things where you can degrade a certain property and defer that damage to a different part of the property, for example, and from an ecological standpoint, best to minimize your degradation of that original property. And so just looking at it through that lens and thinking, how can we enhance and really not damage the environment is what I was trying to get to.
Okay, so I heard a request from the administration, from Director Dollywell, to get some better feedback about stream buffers and the averaging, was it? Or just?
I think the averaging, we can have the discussion with PPC.
Okay.
And I think the stream buffer averaging, we can think more about it, but it is going to be, if we want to go and hash it out, then it's a separate body of work that will need to occur with the resources, with additional time and all those. So what we were thinking was, is it go on the whiteboard, or do we tackle it with this update?
And I think on behalf of the administration, what I would propose is that, let us do a little bit more due diligence. We believe that it's something we need to put on a whiteboard at this point. If the council feels strongly otherwise, I think we'll just need to there'll need to be a motion to request the administration to do that. But again, we're trying to keep this process moving in a thoughtful way, and putting some larger projects, on the side, so that once we're finished with this, we can take that up. So in this instance, I would say that's one of those projects that we would want to put on the whiteboard.
Councilmember Hunt.
I just want to make sure I understand, because my understanding from the earlier comment was that you would return to council with more information about what that would look like. But then my understanding of the last comment was that would not be the proposal, that you would need direction from council to go down that path to get us more information about what it would look like, for example.
And I don't think we have the information this evening to provide more than what we've said. I think what you're hearing from Director Dollywell is that it's a large body of work. My reaction to a large body of work is that perhaps that's something best for the whiteboard. If the council disagrees, then I guess that's a separate discussion that we could have on a future meeting.
Yeah, and the whiteboard doesn't mean we'll never get to it and it just goes on there. You know, we could come up with, like, we can do this by this year. I think Planning and Policy Commission, some members said, okay, if you put it on the whiteboard, just commit to a time frame that isn't too far out. So that's basically what we're, you know, we want to get the rest of the stuff done too. I mean, if we do this and we determine this is what it takes, so we will, you know, our recommendation was to not put it off forever, but with this update, we move forward with all these other changes, and then we will address the newest, because we will learn more. I mean, other cities are going to have dig into it. The Department of Ecology will get into it, and so with time, it'll be more fleshed out and what it means for Issaquah and in our context.
You know, and Council President, members of the council, I have to think that when we come to the end of this process, you know, the council has a budget letter, they have the CIP letter. I bet you there's going to be a Title 18 letter. And I think that will say what, because this is just the first night. I mean, so there's 5 more nights like this plus another 6 or 8 nights once we're getting toward the end. I have to think that the council is going to say, here are a collection of 6 or 8 things that are really important to us that didn't make this final code, and it's our expectation as a city council that here are the top 3, and for the 23 budget, we're going to want to make sure there's money put in there. So if you need additional consultants or additional staff time, my guess is that's how we will likely come down. That's really all up to you in the end. But again, this is night 1 of 6 of these particular conversations.
Well, I think you certainly made it a possibility that that's going to happen.
Well, because there's great past practice by this council to say, and again, the operating budget, I mean, there are some similarities. You try to accomplish a lot in an operating budget, you know, sometimes you can't, but you say, here are things that are important. I have to think this process lends itself to something like that as well. So there's a commitment to the community, to the board, the PBC, the Environment Board, other boards and commissions, that everybody's on the same page, and that's being transparent as we move forward.
Yep, making things that are on the whiteboard official and providing timelines toward them. Okay, so Director Dollywall, any other feedback that you need on this, or are you feeling good going forward?
Great. Thank you so much for your you know, insights and direction. So appreciate everyone's time.
Okay, so I think we're gonna put a check mark on this one. We've been sitting here for 2.5 hours. How does everybody feel about a 5-minute, 10-minute in person? 5? Okay, I think we're gonna go for a 5-minute break before we bring on to the next topic. Thank you.
All right. Hi, thank you.
Council President Walsh, this is Tisha. I'm not able to hear you.
Well, okay.
Oh, there we go. We can hear you now.
Okay, did you hear the intro or do I need to start that over?
We missed the intro. I'm sorry.
No, I appreciate it. Perfect. So I was just saying we are back from our 5-minute break. And so the next item of business is ID 1050, amending IMC 5.02 business licenses. And this is presented by Rachel Bender-Turpin, our city attorney. So it's over to you, Rachel.
Thank you. Good evening, council, mayor, staff. It's nice to be here. The last time we discussed this topic was back in January, and as you may recall, the council passed an ordinance amending the business license revocation criteria, but with the sunset provision, with the expectation that staff would come back with a newly revised ordinance cleaning up all of chapter 5.02. So this is what that is this evening for you. I drafted this with feedback from the Economic Vitality Commission, the Chamber of Commerce, the Equity Board, so I thank them all for providing their comments and feedback. It was very, very useful as I went through and made these changes. A lot of the changes, in fact, the vast majority, it is a complete overhaul, but they're mostly administrative in nature. Back in 2017, the state passed new laws, including a requirement that cities adopt portions of a model ordinance. And so the city did do that in 2019, I believe. It did include the 2 portions that were required. However, a lot of other changes were not made that really reflect the new licensing procedures that the city uses now that we use the state's business licensing service. So for instance, there was a lot of references to old forms and things which people don't fill out anymore. It's all done online. And so staff were also incredibly instrumental in walking me through actually how this gets done, so then I could draft a code that reflects what really happens rather than, what used to happen 10 years ago. So this entire chapter has been completely rewritten. I won't go through all of it with you in boring detail this evening, so instead I'll focus this presentation on kind of the more substantive policy issues that are involved in this chapter. So, I'm sorry, I'm talking so much I'm not paying attention to my slides. I already kind of went over this, but the process started with my first EVC meeting that I got to attend in February. We got to reconvene a couple of weeks ago. We had a special meeting, in fact, just for the purpose of going over the code draft that I had come up with after meeting with them initially. And like I mentioned before, the Equity Board has also reviewed, as has a number of members of the chamber. The first point that I wanted to address here are exemptions. So cities can exempt certain activities from the requirement to get business licenses. I did not make any material changes to those exemptions. I was really focused on cleaning this up and addressing the revocation criteria that had been, concerns had been voiced but from the business community back in January. So I'm just kind of noting this for you. Obviously, it's up to the council to decide if you want to make any other decisions. However, I would note that it might not be the ideal time to change up a lot of these things because it will require a lot of outreach to folks that have been operating under a certain way for many years. But the exemptions, they were actually they were scattered kind of in a strange locations throughout the code. So I took them and I put them in one section called exemptions so that people could easily find them. But most of the ones that you have here are pretty typical. Businesses with only a post office box and no actual business location in the city. Farmers, that's a really common one in many, many city codes. Issaquah is unique in having this special exception for firewood, but I think it's very, very cute and reflects the unique nature of this particular very environmental community. And then there's also an exemption for residential rental activity involving 10 or fewer units. That was one that was actually, it was in a strange location. It was in the definition of business, and that just had made no sense to me. So I said, well, if we're going to have it in there, we should probably put it actually where it belongs, in the exemptions. And then I am on behalf of staff requesting one additional exemption be added, and that is for vendors of software that are contracting with the city for the sale of like off-the-shelf software products. And that's quite frankly because they refuse to get business licenses. You know, we go and we try to buy these products, you know, we as a city, we have a little bit more stringent contracting requirements than I do personally when I just click through and say accept the terms and don't even read the agreements, even though I'm an attorney, because I know that, you know, as single person Rachel, I don't have a whole lot of leverage with these companies. The city has more leverage, but you know, certain companies, they, you know, for instance, recently these came up with a, you know, Canadian company that sold software, and you know, they were a large company, and they really don't care if they get the city of Issaquah's business in this regard, but it was a product that the IT department really needed. And so this has become an issue. They won't get it, so the city either has to add an exemption for those vendors, realize that not contract with them at all, or know that you're possibly violating the code when they don't get a business license. I also created previously all business licensing ordinances generally have requirements or certain qualifications you have to meet to get a license. Issaquah's previously just had one single qualification, which was that the proposed business be permitted in the location that you were proposing for the business. That is obviously a very important criteria to have, but there are a lot of other qualifications that other neighboring jurisdictions use that I thought were very useful. They also matched a lot of the language from the from the revocation language that we had with tweaks, obviously, because I did rewrite those to make them much clearer and cleaner. But it makes sense to me that you would actually look at, if there's conduct that you think that you would revoke someone's business license for, it probably makes sense that they not have engaged in that conduct before you give them a business license. So I tried to kind of make those mirror each other in a lot of ways. So they're pretty standard ones that I included. You know, violating state or local laws, federal laws, but specifically with regard to the proposed business. So it's not you're not looking at people's, you know, entire criminal records and whether or not they, you know, had a DUI or driving while license suspended or something. I mean, you're talking about, did you commit money, like, did you get convicted of money laundering? You know, that's the kind of thing that I think you'd want to know. And then you got shut down somewhere else, and now you want to come open your business in Issaquah. You know, that's a red flag, which is why I also added one, which is prior business license revocation or suspension in another jurisdiction. There is a caveat that I wrote into the ordinance, though, that says that if you had it reinstated on appeal or after engaging in whatever corrective action you needed to do, that doesn't constitute, you know, suspension or revocation.
Excuse me, we've got a question from Councilmember Martz.
Thank you, Council President. What do you do about recreational marijuana, which violates federal law all the time?
Well, that is a good question. Actually, now that you say that, I have seen several in my lots of business license researching. There are a couple jurisdictions that specifically carve out, this does not apply to marijuana retailers that are licensed by the state. So that's something that we could add. I could add language
I
to
think
that
we
effect.
would probably need to.
Yeah, I can do that.
Thank you.
Sure. Take my note. Okay. Let's see. And then obviously the first one there is they lied or misrepresented or concealed something, which is usually probably not a very good, it's not a good initial start to a business, I suppose. Or made a false representation in your renewal as well. And whether or not they were indebted or obligated to the city for past taxes or fees also related to the business. So it's not, you know, your storm water fees on your house or anything like that. We added a time period at the request of the Economic Vitality Commission. So it only applies to fees and taxes exceeding 4 months. I chose 4 months because that matches what the BLS limit is, which they'll cancel your license after 4 months. So it seemed to make the most sense to make those be the same. And then of course the important one that was our previously pretty much our only criteria, which is in violation of any building zoning, safety or health regulations. I added health and safety regulations because there are times where something might be permitted zoning wise, but you know, if it's, you know, a huge fire hazard and out of compliance with your fire code, you probably don't want a business operating in it either. Applicants do have the opportunity to explain extenuating circumstances. We didn't want to have anyone just be completely disqualified from getting a business license based on any of these, because we do realize that there can be a lot of you know, that life happens and there can be extenuating circumstances. So in the event that someone who's applying says, ooh, you know, I did have this old conviction, or, you know, ooh, you know, I am obligated on past due taxes, but I'm working with the city on paying it, then they can just give some written information to the city to consider. The city can then meet with them if they want, get more information, but there will be more of an interactive process there to determine whether or not they sort of meet kind of the intent of the regulations, which is to make sure that you just have businesses operating safely and appropriately in the city. And then we move on to the revocation suspension criteria when those businesses that do get licensed don't continue to operate in the manner that the city expects. What you do about that and what that kind of conduct is. I really just revised all the language in its entirety. It was just it was a little bit wordy, which is saying something coming from me, because I know that some of the stuff that I write is also wordy, but it was, when I can't read it, I think that that's a problem. So I tried to rewrite it so it would be a little bit easier for people to understand. So these are just examples of a couple of the criteria and how we changed them, but just made it clear that we're talking about not being in compliance with the municipal code, that you're convicted of or plead guilty, or a bond forfeiture, which those are pretty infrequent, but to any offense that's related to the business, once again. And then after much back and forth with the Economic Vitality Commission and the Chamber, I changed the language in what was previously subsection C. There was a lot of consternation with the terms peace, morals, and welfare. Those terms, I used them originally because they're actually from the state constitution, and they are kind of synonymous with the city's police powers. But that's, you know, that's confusing stuff. And then you get into, they're not like really simply defined in a statute. You just have to read a bunch of cases about police powers and welfare and health and safety. But in peace and morals. But health and safety, those are pretty standard. So we left in public health and safety, so that. And this, I think there's an error in this slideshow, because I changed it, actually, the ordinance, after we went to the Economic Vitality Commission. So it really just says results in a danger to the public health and safety now. Peace and welfare are no longer in the ordinance. And then there was a concern about whether or not the definition, folks would know what the definition of nuisance was, or if we could point to a specific definition of nuisance. Well, unfortunately, public nuisance doesn't have one definition. It actually has like 10 in the RCW, which is very easy to track down. And then has several within the city, because the city council or any governing body, you can actually just designate what conduct you decide to be a public nuisance. But the way the language is written now, it has to have specifically been designated as a public nuisance. So the city can't just decide that someone's barking dog is a public nuisance. It actually has to meet one of those public nuisance laws in either the state or the city's code.
And if I can just add, Council President, of the, I don't know, 2, 3, 4 hours of community meetings we've had, this has been the major topic.
Yes. And this one is just similar to the disqualification or the qualification for license applicant. Obviously, it's a problem if people are purposefully lying to the city when they submit their applications. These were also a source of contention, and I thought that probably they were a little bit redundant. Back in January, we were trying to address kind of an emergency situation, but now that I could sit and really stare at this stuff for hours, I kind of boiled those down into one. So another thing that we addressed at the request of the community was owners of businesses not being forced to have to try to physically apprehend people or stop crimes in progress. The city's intent was never to have people do that, but the business community felt much more comfortable if we put something in. So we just added language saying that that a business wouldn't be considered as having allowed or failed to prevent, back when I actually took out failed to prevent out of the ordinance, but having been allowed to allowing crime just because their employees didn't chase after someone who was stealing something, or fight back if someone was trying to rob them. So that seems like more than fair, and that's what we want anyway. So we've cleaned that up and made it clear. And then once again, I added the language regarding past due debts and obligations. This actually kind of needs to be here anyway, because, well, the state's going to just cancel your license anyway. So probably good to have our own code match that as well. The violations, I'm proposing that these be civil violations. I say that as a former prosecutor. They're not very easy to, they're not going to be easy to prove in criminal court, and I don't think any prosecutor is going to file charges on these, because you're not necessarily going to have the mental mens rea element with businesses. The executive of business probably doesn't even know what's going on the floor of the business. Current code allows for penalties of up to $250 per day. Staff, just as a heads up, will be coming forward in the next few months with amendments to the code enforcement code, and then we'll have to come back and clean up the references in here to match that. But this will at least give us some enforcement mechanism in the meantime. I have written it so that it's administered by the city administrator. It was previously the building official, which I have to say that's the first I've seen for business licensing. Often it's the finance director, but building official is a new one for me.
Rachel,
yes.
I have a question from Councilmember Joe.
Yes, Councilmember Joe.
Thank you, Council President Walsh. Good evening. I was looking at the penalty section, and you had referenced that we probably want to make this a civil violation. The language in there refers to
either.
Or it says that shall be guilty of a violation of this chapter. And guilty carries a connotation of beyond a reasonable doubt and criminal procedures. So is it your intent to kind of clean that up so it's just a civil violation and a person that violates this section will be subject to a fine?
Exactly.
Okay.
We'll just, that entire section that you're looking at, that's being completely rewritten. So without that guilty language in it. So then we'll just refer it to the new chapter.
Okay,
Instead.
thank you. Appreciate that.
And appeals. Currently, appeals go to the city administrator, which is nice for efficiency purposes, but I think it makes sense to have appeals heard by the hearing examiner, who hears most of the city's other appeals. So we're here tonight at the study session. This is on the council's agenda for the regular meeting on April 4th. We have to adopt some regulations by the 18th, I believe, or the prior code ordinance will sunset and the code will revert to what it was in place prior to January 18th. Does anyone have any questions?
Okay, Councilmember Ray.
Thanks, Rachel. This was great. And I know that you mentioned a couple times that you engaged with the chamber and other business. I guess you said you engaged with the chamber. Were there any other business entities that were also involved in these discussions, or was it really the chamber that was kind of leading the charge from the business perspective?
If they were filtering it through the chamber.
Okay.
I do believe that there were folks speaking with them about it, but it was all of the comments that I received were from members of the chamber or the EVC sending emails to staff.
And Council President, Councilmember Ray, Jen Davis-Hayes, our Economic Development Manager, is on the line. I think she might be able to add. I know there were some additional discussions.
Oh, good. I'd love to hear what
Jen?
Jen has to say.
Hi, thank you. Yes, hi. So Jen Davis-Hayes. And so I actually wanted to mention that we have a member of the Economic Vitality Commission here to provide a little bit of feedback about that process and input. So I don't know if now is the best time for that, or you want to wait to hear that later. But the EVC did have 2 open meetings about this, where there were no extra businesses that actually were there to comment, but of course there are business representatives on the EVC. So Chris Richley, who is a member of the EVC, is available to speak if that's appropriate time now.
Jen, that would be great, and thank you for coming on, and thanks, Chris, for showing up.
Yes, thank you. Good evening, council members and Mayor Pauly and staff and everybody else in attendance. My name is Chris Richley, active commissioner with the Economic Vitality Committee. Just wanted to kind of give you a background, like Jen said, on the feedback that we were providing to Attorney Turpin regarding the changes. So the commissioners were in agreement with the suggested languages in the updated revocation and suspension license, particularly in sections 5.02.130A 1 through 3 and sections 5.02 and 0.130A 5. We did have some, discussion around the language and the ambiguity of the words, peace and welfare, like it was brought up. And basically, we appreciate the edits to just basically say maintain health and safety. It was a lot, right there, to cover, but just maintain health and safety. After discussion, the enforcement of public nuisance makes sense to follow the definition as outlined by the state law. Commissioners we did recommend striking the phrase failed to prevent in section 5.02.130 A5, and then just basically add clarity as, Attorney Turpin did, in particular to the business owners. As business owners, they can't technically prevent. It's not like no businesses want to prevent a crime from happening, but they can implement a system that may not be enough to prevent the theft, right? But I work at a credit union. I manage the Harborsham Credit Union up in the Highlands. I can't prevent a robbery from happening, so that's where we're kind of going with that. Different businesses, so that's why we're looking at that. Commissioners also suggest adding clarity on section 5.02.1 or 0.130A7 related to whether businesses who are past due were in fact working, with the city. We needed to have the verbiage in that they're working together with the city to get it resolved, and then suggested adding the working in good faith, having that time frame also implemented to hold them accountable to making sure their fees are paid and taxes and whatnot. So we're continuing to, help them move along business, but then also we're not enabling them to continue not to take care of something that's outstanding. The commissioners expressed their gratitude to the staff for their hard and thoughtful work in updating the section of the code, and we're supportive of all of their changes being presented. So I appreciate the time to talk tonight in front of you all, and turn it back over to you, Jen.
Well, before we turn it back over to Jen, I just want to say, Chris, thank you very much for staying here late as we are getting through this as a second item, and your service on the commission. It's really, really important for us to hear directly from the commissioners. So Jen, thanks for orienting that and making sure that happens. So thank you. Okay, and so I guess we're going back to Rachel at this point, I think. So actually, you've finished up your presentation, so we're ready for questions, seeing if there are any other questions before we go to public comments. Anybody questions? And I'm checking chat to see anything from Councilmember DeMichelle. Not seeing any, so I'll just ask Councilmember Joe.
Sorry for the late hand raise there. I'd like to just do a couple of comments. As the liaison for the chamber, I've had a couple of opportunities to talk to the board about this issue, and certainly appreciate City Administrator Bobkowitz accompanying me on those meetings. And one of the things that I think was important in our outreach to the chamber was discussing the fact that the code is not just enforced by its cold hard letters necessarily, that if there is a violation that is seen or a violation that is potentially coming forward, the code enforcement officer, the police department, other city officials, as well as the city administrator work with that business to try to mitigate or rectify the situation before we get to the point where a revocation is necessary. And so while the code is there, there's discretion with the officers and the officials in the city as they go forward. And then the city administrator, of course, has some leeway as he exercises his discretion as well to try to make sure that the businesses are adhering to the law, but are also understand that it's a work in progress. It's a relationship of give and take between the administration, the city, and the business itself. And I think that helped convey to the chamber and the other interested parties that the code's the code, but it's not followed by the strict letter of the law. There's a lot of discretion involved, and I don't know if City Administrator Bobkowitz would like to comment or add additional color to that.
No, again, the Councilmember Joe is absolutely correct. We had a long discussion at the chamber board meeting last week, 2 weeks ago, about this whole issue of discretion. And again, the compliments to the chamber board for taking the time to be as thoughtful with this subject as possible. I think Councilmember Ray's question about other businesses, I know Jen regularly meets with Downtown Issaquah Association, the Highlands Business Group, Gilman Village, so they were all made aware of that, but I think we're encouraged to go to the Economic Vitality Commission with those comments. So I think we did cover all those bases, and I thank Councilmember Joe for all the work he did with the Chamber Board over, I guess it was 3 meetings.
Okay, so I'll just enter in my question. So I notice in the code around who would be exempt from having to get a business license, there was something relating to rental units and landlords with 9 or fewer rental units at a single location. So I'm wondering if you can talk through that exemption, because I think we had an email exchange saying that's kind of unusual, and so give us a sense of what other cities around the area do. And I think you said previously, maybe if we want to address that, maybe not doing it within this scope, but having an understanding of going back and getting some more feedback. So if you could talk to that as well.
Yes. So most cities don't exempt the landlords from these business license requirements. Most of the time, most cities I've worked in, you've had to get a business license for any rental that you have, even people that just rent a single house. Some cities do have thresholds. So if you rent, 4 or more units or 3 or more units somewhere, especially if they're, located in a similar place, you rent a duplex somewhere, that maybe those 2 then are exempt. Issaquah is a little unique, and I feel like there must be a story here that none of us were around for, because 10 or more is what it was, so 9 or fewer it's a pretty large number, and it's kind of just a random number. So I that's almost why while yes, it is unusual, I would be hesitant to change it at this point without looking into this more and doing some further analysis, because first of all, I don't know why it was set like that, and second, it would require a lot of outreach to those, I guess, landlords or those, various apartment buildings that have fewer than 10 units. And I'm not really even sure that the city has, has any ability to track that. So it sounds like a kind of a large undertaking, but yes, it is unusual. It's a high number.
Okay. That answers my questions. I'm not seeing any other questions and nothing from Councilmember DeMichelle. So I think at this point we'll move to public comments and then to council feedback. So clerk, do we have anybody who's indicated a desire to speak?
Yes, we do, Council President. I also wanted to indicate to the attendees that if you're joining virtually and would like to make comments, you can raise your virtual hand if you're on the phone by pressing *3. And if you're on a computer or smartphone, look for that hand icon. I do see one hand raised. Kathy McCory would like to speak, so hopefully we can avoid the problems we had prior.
Perfect.
Ms. McCory, you should see the option to unmute, and you can also join us by video.
Fingers crossed you can hear me this time.
Yes, we can.
Yes, 3 computers later. Thank you, everyone. I just want to first off start by acknowledging City Attorney Turpin and Jen Davis-Hayes and other staff members for all the time that they took to make sure that we were able to reach out to the business community, gather input and ideas, resources, etc. We did an exhaustive search, as well as, just so you know, I also sit on EBC, so I was part of all of those meetings, bringing information back and forth from our chamber board to EBC and vice versa. But we reached out to not just the retailers. We had a retail roundtable. We reached out to a cross-section of small and large businesses. We invited and had meetings with shopping center owners, as well as following up with Target and a few other of our larger retailers. We reached out to AWB and the WCCE and the Retail Association to actually guide us through this process as well, just to make sure that we had a thorough understanding of what this code means and the importance to the community, because as everyone else, we want our community safe. We want to feel good when we go out and go shopping, and we want our businesses to succeed. So the health and safety, of course, is key. I feel that this was a great effort on everybody's part to get us there, to provide an ordinance that offers health and safety, not just for the businesses, but for their employees. and their customers. So I do think that that was accomplished in this. I do want to say that in our process, just so you're aware, all of this went back to our Government Affairs Committee. So it was seen by a cross-section of businesses there as well before it moved forward to the board. And then, of course, to City Administrator and our representative, Russell Joe. So a great process. Would like to be able to set that as a great example moving forward when there are issues that concern our businesses. So basically, all in all, our position is that we don't see any issues with this ordinance. There was a question we had, and it might have been asked and answered by now, and that was actually something that didn't come up in EBC and wasn't really on our radar from our meeting with City Council back in January, but about one business in multiple locations. I did go online and I saw that there are many businesses that have multiple licenses in the city already with the state, and our own comment was if that's something that you do when you apply through the state business licensing, we were fine with it. If it was something new, we'd like a little bit more information about that. But that was really our only concern. Thank you so much for your time.
Thank you, Kathy, and thank you for staying late and being able to provide comments. Clerk, do we have anybody else who has indicated a desire to speak?
Council President, I do not see any other attendees with their virtual hands raised.
Okay, sounds good. And so at this point, I think we're looking for feedback from council. Deputy Council President Hall.
Thank you very much. I just wanted to share some additional takeaways from conversations that I had with the Chamber, with Raleigh Properties, and with the Downtown Issaquah Association as well. And that's largely support for the actions that we took to address abandoned shopping carts and unchecked retail theft. I think in particular, I heard most often that it was unfortunate we had to force a behavior change in this way, but there was also a recognition and an observation that there's definitely improvement in the community. And finally, in considering this update that we see today, that we're measured in nuance, that we get, that we work to get the outcome that we want, which is a safe Issaquah, but also prevent unintended consequences down the road. So with that, there are 5 sections I wanted to provide comments on. The first is was just mentioned by the Executive Director of the Chamber, Kathy McCory, 5.02.050B. I'm just not going to list off the titles from now on, but this is the section that describes how businesses operating in multiple locations need multiple registrations and licenses. Based on the feedback that I got in my own research into it, if it's not a state requirement, I don't think it's necessary. I think we can remove this. I think that this code update is an opportunity both to address public safety, but also to consider how we support business growth in town. And this is small, but it could be meaningful to small businesses growing. So it seems like a little bit of a no-brainer to me, assuming there's no state requirement or new administrative burden on staff that would present a problem. So that's feedback on that. We heard a little bit already that there's still some concern from the business community about using the phrase public nuisance, and Rachel got to this already, so I will limit some of my comments here. But just to say too, and to acknowledge what I've heard from the business community, and that is there's a wide range of public nuisances that can be in different jurisdictions, and be really difficult to narrowly define that. And even in the event a business is creating a public nuisance, our first action wouldn't be to suspend or revoke a business license anyways. There's a pretty well-established process for notifying a business owner and asking them to stop before we even begin to think about due process anyways. So no change here, just acknowledging what I've heard. And then 5.02.1306 is definitely the real meat and potatoes of the public safety discussion that we're having. I'm happy to see failed to prevent was removed. I think we did find the sweet spot with how it's written right now, because no one's interpreting it to mean that owners or employees need to intervene. Obviously, what we mean is calling 911, reporting the activity, and allowing law enforcement to do their thing. Okay, so Chapter 5.02.140 is a section that says a business has 13 days to file an appeal after the city mails a notice, either denying, suspending, or revoking a business license. I had some conversations with the Chamber Board leadership on this. I agree. I think that this time frame might be on the low end, and I'd like to see it change to somewhere between 20 to 30 days instead. This is just another opportunity to consider how we can support growth and recovery for businesses in town, give them a little bit more time. They've got a lot on their plates. And then the last one for the appeals process in general. See, I don't want to repeat everything that Rachel's already said. I agree that transitioning from a hearing examiner or to the hearing examiner would ensure objectivity, and it would definitely help with the equitable application of discretion, which was one of my major concerns when we first passed this ordinance a few months ago. But another concern is timeliness and predictability. And I had asked the city attorney whether or not we could add a timeline to the hearing examiner's decision. And what we heard back was yes, and that we should wait to include that in the new code enforcement regs, which you already mentioned tonight. So thank you. And in the meantime, there's already this hearing examiner rules that require a decision within 10 working days. So I'm feeling pretty good about waiting and tackling the code enforcement regs later. So once again, no change, just acknowledging to the business community listening that we heard that. And then, yeah, add the exemption for marijuana retailers, as Councilmember Martz mentioned, good point. And then the civil violation section needs updating, as Councilmember Joe mentioned. So those are my comments. Thanks.
Okay, and we've got a comment from Councilmember DiMichele.
Thank you. I have a comment, but first, is it all right if I ask Councilmember Hall a question?
Certainly.
Councilmember Hall, at the beginning of your remarks, you said you wanted us to drop a item. Could you just read the item, because I'm like rushing through and looking at it. I couldn't find what it was that you were talking about, and I don't know what you're proposing to have dropped. So could you read that to us?
Councilmember DiMichele, was this in reference to this section describing how businesses operate in multiple locations? That one?
It was the very first thing. It was the very first item that you brought up, and you said you thought we should just simply remove it.
Yeah, so that's toward the beginning. It's chapter 5.02.050B.
Yes, what's the wording there? So.
If a business is conducted from more than one premises in the city that is rented, leased, subleased, or owned by such business, a separate registration and license shall be required for each premises within the city. So quite literally, just if you're operating out of multiple locations, each of those locations need its own business license. Is that correct, City Attorney Turpin?
That is correct.
And you're asking, and you think that should be dropped because?
I think that this is an opportunity. I guess I'm just not seeing it as a necessary action for the city to document all the different, or to require a business license for each premises that a business is operating out of if we already have an overarching business license. This is also what I heard from a couple members of the business community in connecting with them, and I think unless there's some new administrative burden that we would bear on city staff, or if there's some state requirement that I'm missing, I just am not seeing a reason why to do that.
All right, thank you for the explanation. I guess my feeling would be, before we do that, I mean, that's just, just bringing it up here tonight, I need to know the implications of that. If we could get that before it's brought back to us at the next meeting, I would appreciate that. Or if we could just get, just a commentary from our attorney, that would be really great. So I'd just like to know what the implications of taking that out would be. So my own comments on this, first of all, I really like the public outreach that was done on this, and the Economic Vitality Commission and the Chamber, but I also want to recognize that it was brought before members of the Equity Board. And this is exactly, I think, how we envisioned that the Equity Board would be used to look at everything that we're doing. And particularly, this is one that involves penalties, and it could involve small businesses that are owned by minority owners. It could involve businesses owned by women, so forth. And I really applaud the fact that the Equity Commission, or Equity Board, excuse me, was able to weigh in on this and take a look at it through an equity lens. So many thanks to Rachel Turpin for being sure that they were included. I think this kind of process is how we get really good legislation. Reading through it, I think we are accomplishing everything we wanted to do with the original piece of legislation, but we have listened to the community, and the community was able to help us put the wording in such a way that it also works for the community. And to me, that is a really good piece of legislation. So I really commend the process for this. And Rachel and I went back and forth on the wording on one of the sections, and I think she updated it for the presentation tonight. So I don't have any comment on that part. Overall, I am very supportive of the ordinance, and I don't find anything that I would change at this point. So again, thanks for the process and thanks for the hard work on this.
Thank you, Councilmember DiMichele. Looking at the other, no. Councilmember Hunt.
I have a question about the multiple licenses. Do you know what other cities, neighboring jurisdictions do on the multiple licenses?
Most of them include that requirement, and the reason is that the BLS system doesn't, and I actually just went in and made a pretend business to fill out the form. It only lets you put in one address, and one of the purposes of the application is to see if you meet the zoning and the requirements at the proposed address. So I think that's the primary reason why folks include it. The state actually, it's not a state requirement that cities do it, but the state actually requires it for their own business licenses. For the state business license, you have to get a separate one for each location. It just has that downside. I was hoping that there'd be a way that you could add multiple locations, but it doesn't seem to have that capability in the BLS system.
Well, my comments, I agree with what Councilmember DiMichele said. I think that this has gone through a process with a lot of feedback, which I appreciate. On the multiple licenses, which has come up a few times, I was wondering also if you have a business, then you add a location, that new location has new management and something specific about it, and you didn't have to get a new license, then the city has no knowledge of that additional location and if there's a problem there, et cetera. So I was just thinking, unintended consequences seem like they could be along those lines. So I wouldn't support it at this time, but I'm open to hearing more information about the pros and cons of it because I hadn't really received much information about it before tonight.
Councilmember Joe.
Thank you. I appreciate the process that we went through as a city to reach out to businesses large and small. I appreciate the input from the chamber as well. As we as a council and the administration try to wrestle with this, this section, we do need to keep in mind that the actual fee is $60 initially and $50 every year after, and that it exempts businesses that earn less than $3,000 in a year. So we have to kind of measure how much time do we want to spend making changes to this versus how much income actually comes in. And then also, we also want to think about, we want to make it so that people want to register rather than have to register it at an onus, a very hard process for them to make that happen as well. So we want to encourage compliance. We want to make sure that it's a low barrier to filling it out. And then we as a city need to make sure that we're putting the appropriate amount of time for the amendments in there, given the amount of income that might be coming from this section of the code. So I think we have great ideas that have been tossed around through this process and tonight, but we just need to kind of keep in mind the ultimate goals for this section. Thank you.
Okay, I'm not seeing any other comments, so I will make my own. I'll plus one to the previous comments of great process, really good engagement. Lovely to see the feedback received and the iterations that went on it, and not just that, but then going back to the stakeholders and saying, okay, we made these changes, see how your comments impacted the results. So really liked that. City Attorney Turpin appreciated that it wasn't just an effort to let's just rewrite and change that one area where there was the most concern. It was also a review that gave us the opportunity to change this so that it's administered by the city administrator and the appeals are heard by the hearing examiner. And we review the qualifications for a business license as well as this kind of intention point of the criteria for suspension and revocation. So I think this was well done all around. I read through it as someone with a city business license, trying to make sure that I would fit each of the criteria and, you know, what this meant for me. And I came away, I love it when I can read code and understand what it means for me. And so I think for me, this checks all of the boxes, and I feel very comfortable with all of this moving forward. So thank you. Seeing no other comments, I just want to make sure, City Attorney, that you have everything you need feedback-wise, and it looks like we're on schedule then to have this come back for a vote at our next regular meeting. Okay.
I do. Yeah, I did make the revisions to section .130 A6 that Councilmember DeMichelle referenced. I just cleaned up the language regarding the no duty to intervene, so you'll see that come back in the packet or the version that goes to the packet Monday. And I've already made the change to the guilty language and added the marijuana exclusion as well. So
that was what I was just gonna ask for.
Here.
Efficiency, I love it. I love it. Okay, so I think that is the last item of business. So at this point, we can adjourn at 10:02 p.m. Thank you, everybody. And Councilmember DeMichelle, I assume you will stay on